May 2023 at 09:30. This meeting, I'm going to have a slight variation in the introduction of this meeting, honorable members, and it would have the same outcome. I do realize many of us seem to have load shedding, and you can even see my color on the screen. That's because additional lights are being used to announce myself. As a reminder that this meeting will be televised, and also that this meeting is streamed by the Parliamentary streaming services. So you need to switch on your videos, please, when you speak. You're all very welcome to this meeting. So included would be the honorable members, it would be our support staff, it would be members of the National Department of Health, state law advisors, of parliamentary legal services, and members of the media and all other members of the public who would have joined our meeting. Before I continue, I'd like to get attendance and apologies from Ms. Majalamba.
Good morning and thank you, Chair. Present is Dr. Jacobs, Ms. Geller, Dr. Harvard, Mr. Kaba, Dr. North-Nahal, Ms. Wilson, Dr. Tembekwayo, and Mr. Van Staden. I haven't received any apologies yet, Chair. Thank you.
Thank you very much. Honorable members, we may proceed with this meeting. We do have a quorum. Now, before I get to the purpose of the meeting, this time I want to read our preamble, just to remind members that this virtual meeting is deemed to be in the precinct of Parliament and therefore constitutes a meeting of a committee of the National Assembly for official purposes only. In addition to the rules of virtual sittings, the rules of the National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in the sitting of the National Assembly. Members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the microphones are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. Members may make use of the icons on the bar at the bottom of the screens, which has an option that allows a member to put up his or her hand to raise points of order. The Secretariat will assist in alerting the chairperson to members requesting to speak. When using the virtual system, members are urged to refrain or desist from unnecessary points of order or interjections. And we had raised this a number of times, that instead of shouting on the platform, please raise your hand on the virtual platform and I will recognize you. Now, in terms of our agenda today, honorable members, it's a long agenda. We note that we have, this meeting will stretch between 9:30 and 1300 hours, but we have a number of things to go through, and I am hoping that it would be a calm meeting, where we'll be able to complete the work that is set before us. Firstly, we will have deliberations on the legal opinions on the NHI Bill as represented by the SLA and the PLS. You would remember that we had a meeting on the 9th, I think it was the 29th of March, where we had then postponed our meeting to allow or to fulfill the request of some of the members who wanted to present a legal opinion on the NHI Bill. After that, we're going to have a clause-by-clause deliberations on the NHI Bill. I will indicate how we are going to do this, and then we will have instructions on the A-list preparations, after which we would have consideration and adoption of minutes of the previous meeting. Now, in order to get the rules clear, I'm going to read what we are going to be doing. So essentially there are, I mentioned, 4 processes for today. On the first one, we will proceed directly with the first one, unless I have left anything out, which I needed to mention. The first part is the deliberations on the legal opinions on the NHI Bill presented by the State Law Advisors and the Parliamentary Legal Services. And for this, I'm going to ask your input. You'll remind yourselves that I had said I will give each political party 5 minutes in which to state their cases. And after that, we will continue with the other agenda items. After that, I'm going to just state on the clause-by-clause deliberations on the NHI Bill that I think I will deal with this matter when we come to it, and I will also put the manner in which this meeting will proceed once we have completed the first section of this meeting. So, honorable members, I will now allow hands for those political parties which want to give input on the legal opinions which were presented by the State Law Advisors and by the Legal Services of Parliament, and those who would have received their own legal opinions. I see the hand, and you'll have to be a bit patient today. I see the hand of Honorable Clark. Any other hands? Honorable Van Staden. In that order, honorable members.
Thank you, Chairperson, for the opportunity. And I'm going to present our report in the meantime. The DA unequivocally rejects the National Health Insurance Bill. The DA has always been in support of universal health care, especially for the poorest of the poor. However, a bill of such nature cannot be haphazardly thrown together without proper and due consideration of all material facts and circumstances in which South Africa finds itself. Should the bill pass, it will do exactly the opposite of what it's trying to achieve, bringing a total collapse
Honorable
to the
Clark,
healthcare. Yes.
can I just please ask you to switch on your video? I have made that request to all members today.
Okay, I'll do that. No problem.
I request all members to switch their videos on today. Thank you. Please continue.
Okay. Should the bill pass, it would do exactly the opposite of what it's trying to achieve, bringing a total collapse of the healthcare sector and ushering in of another form of state capture, which the state being the sole provider of the service to the public. The DA is thus not able to recommend any amendments to be made to the bill as a whole fails in its entity in both constitutionality and the ability to be practically implemented. The DA rejects the bill on the inter alia and the following grounds. Impossibility of implementation. Sorry, can I just put my phone on silent? The bill fails immediately on the basis that the provision in the bill simply cannot be implemented due to many various reasons, such as poor service delivery, lack of staff, lack of ambulances, the consideration that the poorest of the poor will not be able to meet a strict requirements of certain provisions in order to obtain healthcare, locations of service providers in rural areas, and the very real threat of tender corruption, fraud, and looting of the fund. Certificates of need. The bill makes vague reference to certificates of need. However, whether expressly mentioned or not, certificates of need have been declared unconstitutional and are subject to the constitutional scrutiny of the Constitutional Court still. Until such time as this has been done, these clauses in the bill are unconstitutional and are such a material aspect to the bill that they cannot be served from the remaining. Overwhelming powers are given to the Minister. The Minister of Health is given unreasonable powers in the implementation and running of the fund. The minister essentially steps into the role of the CEO of sorts and is actively involved in the day-to-day running of the fund, which cannot be allowed to happen. If this were to happen, we would see a complete overreach of power and influencing the decision of the board. For some reason, the minister may also be involved in the appeals process. He should be playing no part in this process. The minister also has powers to determine the price of healthcare services and has the ability to determine which service providers would be entitled to be paid over another. The board powers are only asking for fraud, corruption, and state capture to be allowed to run rampant. The fund is supposed to be an autonomous entity. However, in reality, it's an extension of the minister. The minister is entitled to select the members of the board as well as the chairperson. The minister should have no powers in appointing, as this will be nothing more than cadre deployment, which we have seen decimate every single SOE in South Africa. All appointments should be open and transparent and done by Parliament. Ability to fund universal healthcare. The bill will not be able to realistically provide reasonable healthcare to all people in the current climate of South Africa. By removing the two-tier healthcare system, you will now be overloading and already overburdening the public health system. Currently, the Department of Health has billions of rands in medico-legal claims. If the entire health budget were to be directed to the fund, it would almost immediately bankrupt the fund, and it would not have the ability to pay the service providers, let alone within 30 days of invoice, which all ANC government entities and departments are already failing to do. Public hospitals already are suffering from lack of budget, understaffed, lack of equipment, beds, sheets, medical supplies, and even electricity and computers in some hospitals. There is simply no way that the NHI will be able to provide adequate healthcare to people in South Africa if the basic infrastructure is not fixed first. In fact, the Minister of Health recently admitted that the public healthcare system would need approximately 200 billion rand to fix the current infrastructure before it can even consider NHI. Accredited healthcare providers. The bill provides that only accredited healthcare providers are entitled to provide medical services to people by the means of the fund purchasing these services. However, the Council for the Health Accreditation confirmed in the committee that they do not have the resources to inspect each healthcare facility provider. This would certainly violate their right to their choice of occupation or trade. Additionally, of those who have been inspected of accreditation, the overwhelming majority of service providers failed in the accreditation due to a host of various issues. If they are not accredited, they will not be able to provide services. This applies to almost every single public hospital, and results of them not being able to provide services would be catastrophic. Additionally, if the government were to try and exempt these institutions and allow them to provide services, it would be unfair and unreasonable to those who have been required to be accredited, and any operation of these institutions would be ultra-virus in the act and the bill currently. Centralization of powers from provincial authorities. The usurping of provincial powers and duties from the provincial health department may be unconstitutional and violates the constitutional framework from which the provincial departments are entitled to operate. It is clear that the department, in drafting this legislation, had not undertaken a proper impact assessment insofar as the relationship and existing health legislation is concerned. Removal of medical providers. The bill eventually removed the option of people from choosing whether to be a part of a medical aid scheme. This may pose constitutional challenges and is now affects a person's right to choice, freedom of association, and undoubtedly the right to access to medical care. Currently, persons paying for medical aid have the choice of medical services providers or hospitals and are almost guaranteed swift, immediate medical attention. If this bill enacted and there's even a slight delay in being able to provide immediate medical treatment and any change of quality thereto, this could result in a breach of these persons' rights in terms of the Constitution. National Health Information System. The bill makes provision for a database to gather all persons' information relating to the NHI. There are serious concerns of data breaches and breaches in terms of the POPI Act. There has been no clarification of what is being done to prevent any information being leaked or lost. Additionally, the practicality of maintaining a single database is unrealistic with many hospitals and service providers not even having access to internet, phones, or computers. How would they realistically capture this data?
I've given you now 8 so far. Please wrap up in 2 minutes and give every political party 10 minutes then, but please, it can't go all day long. Thank you.
Okay. Let me go to the source of funding, Chair, because this is a very important part if I need to wrap up. There has not been any form of feasibility study or test being done to determine the exact costing model and whether Parliament and Treasury are able to provide such funding without jeopardizing the quality of healthcare. We cannot use historical figures to determine whether we are financially able to afford it. In any event, even when the studies were conducted within the bill, most failed the criteria and that was measured against. Treasury is also not committed to being able to fund the full NHI, and the Standing Committee on Finance in the National Assembly has also not been briefed or deliberated upon on the ability of the fund of the NHI. Chair, I will go in conclusion, but I will submit my full report to you because I'm not being afforded to present my full report. In conclusion, above are just a handful of some of the concerns.
Honorable Clerk, it's been indicated many times you'll have 5 minutes. I've given you 10. Don't make a statement like that. You hand in your report, but don't make that statement. Please.
I will continue the conclusion. The above are just a handful of some of the concerns and reasons of the DA rejecting this bill. It is clear that there is no affordability study to confirm whether South Africa could ever afford to fund the NHI, which it cannot. If this is the case and every other single point falls by the wayside and the bill becomes defective from the outset, the bill cannot be enacted where it cannot reasonably come into operation and practicality achieve its intentions. There are a host of constitutionality issues which will be tested in the Constitutional Court when the bill is inevitably pushed through Parliament by the ANC majority. The DA's only recommendation would be to completely scrap the bill in its entirety and for government, political parties and civil society to work together to find a practical and achievable way of attaining universal health care. The DA thus can only reject the bill in its entirety and does not support it. Thank you, Chair.
Thank you very much. Before I hand to Honorable Van Staden, Honorable Clerk, you've had many opportunities to deliberate. This is not the moment for grandstanding now. This is a moment where we're dealing with the legal applications. And that is in any case, the title of the discussion which we are having right now. But I've afforded you 12 minutes. Thank you very much. Honorable Van Staden.
Thank you much, Honorable Chairperson. Let me just lower my hand here. The Freedom Plus obtained a legal opinion from statutory attorneys, excuse me, on the National Health Insurance Bill. And I think the first question we want to ask is, does this bill pass constitutional muster? On Section 27 on the access to healthcare, the provision of healthcare is a constitutional right as obtained in Section 27(1) of the Constitution. What this section provides for is the right to have access to inter alia healthcare services. Section 27.2 in its essence determines that it is the duty of the state to take reasonable legislative and other measures within its available resources to achieve the progressive realization of access to healthcare services. In practice, the services to be accessed are limited by the practicalities in providing such access in respect of available healthcare resources and the cost of such services. The bill similarly refers to the same goals and similarly wording in preamble. Excuse me. Section 27 of the Constitution imposes a positive obligation on the state to realize the right of access to healthcare within the state's available resources and a negative obligation not to take steps that are retrogressive. In considering the aforesaid is there a high risk of a bill not achieving its objectives, the state could fail in its positive obligation, and if the bill results in reduced access to healthcare services, the state would also fail in its negative obligation. We are referring to the matter of Sabrumi versus the Minister of Health, KwaZulu-Natal, which was decided in the Constitutional Court and gives a practical illustration of the application of Section 27 to the Constitution. In ex parte chairperson of the Constitutional Assembly, in the recertification of the Constitution of the Republic of South Africa in 1996, the Constitutional Court made a point that socioeconomic rights could at least be negatively protected. Negative protection is a form of judicial protection conventionally given to civil and political rights. This means that there is a negative obligation not to interfere with someone who is enforcing or exercising a constitutional right. This means that the court can prevent the state from acting in ways that infringe the socioeconomic rights directly. The right to healthcare should therefore not be subjected to deliberately retrogressive measures that is denying individuals the existing access to, for instance, healthcare. A law leading to a decline, rather than progressive improvement in conditions, could be a violation of this negative aspect of the socioeconomic right and could be declared invalid for this reason. The positive obligations imposed by socioeconomic rights are subject to progressive realization of the right of access. Turning to the requirements of progressive realization, the Constitutional Court in the Sabrumi case made a decision, and I'm not going to read that decision of the court. This decision of the court suggests that the positive dimension of a socioeconomic right is realized or fulfilled through the state progressively or over a period of time. The burden is on the state to show, excuse me, but it is making progress towards the full realization of the rights. The socioeconomic rights are further limited by the qualification that they are only available to the extent that the state resources permit. In the absence of available state resources, the failure of a state to address socioeconomic rights is therefore not a violation of a right. The content of a thematic report on public submissions confirmed that both National Treasury as well as the Davis Tax Committee has expressed its reservations in regard to available funding for the NHI Fund. If the National Health Insurance Fund has been fully implemented, medical aid schemes may only offer complementary cover to services not reimbursable by the NHI Fund. This in return means that more than 9 million people who are now carried by private medical aid insurances will then become the burden of a state. There is therefore an argument that the intended legislation will increase the burden on the state instead of strengthening the capacity of the state, even if one assumes that the contributions which could have been paid over to medical aid schemes is now contributed to the NHI Fund in the form of imposed tax. It is therefore argued that the possibility exists that instead of improving the right of access to efficient healthcare services, the existing right to access to healthcare which members of private medical aids currently hold and pay for may be diminished by the very bill which aims to achieve a realization of this right. It is admitted that some of the provisions contained in the bill will have a further likely effect of preventing access to healthcare services, especially if a person who is eligible to receive healthcare services have not registered with the NHI Fund. The prescribed referral pathways are in conflict with the Patients' Rights Charter, which makes provision for the right of patients to choose their own healthcare provider or health facility. Referral pathway rules would prevent people from continuing a relationship with their doctors of choice and were prejudicial to pregnant women who prefer to engage their regular gynecologist or obstetrician. The proposed referral pathways place continuity, quality, and efficiency of care at risk especially for patients with complex conditions or long-standing chronic conditions. There would be unnecessary waiting periods as access delayed may be access denied. The prescribed referral network could limit access to care. There is a lack of clear guidelines for referral of persons with disabilities and their families from rural areas to designated state hospital, and no recognition of their need for transport and accommodation. This could limit coverage and or increase costs for users who had to travel to other facilities because the nearest facility was not accredited. The draft bill does not clarify what specific healthcare services are to be provided. The bill defines healthcare services as healthcare services including reproductive healthcare and medical treatment contemplated in Section 27 of the Constitution. This definition does not advance the interaction between access and what is to be accessed. Whilst Clause 2 of the bill proposes a mandatory prepayment system to achieve sustainable and affordable universal access to quality healthcare services, the services remain obligate and unclear. Given the high risk of a bill not achieving its objectives, the state could fail in its positive obligation, and if a bill results in reduced access to healthcare services, the state would also fail in its negative obligation, which will in turn give rise to a constitutional challenge. Another way in which the bill would not pass constitutional muster is in its treatment of the rights of asylum seekers and migrants, and I'm not going to entertain that, it's too long now. In terms of the bill, any asylum seeker will no longer enjoy access to primary healthcare services should the bill therefore pass and limits the rights of asylum seekers to access to healthcare. This will have the effect that the state will be impairing existing rights. It will also have the effect of violating the non-refoulement principle if asylum seekers are forced to leave because of failure to access to healthcare. The right to freedom of trade and occupation and profession of Section 22, Clause 2 of Chapter 1 of the National Health Insurance Bill provides that the National Health Insurance Fund will serve as the single purchaser and single payer of healthcare services. This provision may possibly infringe on Section 22 of the Constitution, in that the National Health Insurance Fund may very well monopolize the healthcare insurance industry. The aim of the Competition Act is to prevent and prosecute anti-competitive behavior and allows the Competition Commission to investigate such behavior at the risk of a possible fine. The wording of the Act may have the end result and opportunity for anti-competitive behavior. Section 2171 of the Constitution provides that when the procurement for goods and services are undertaken by organ of state or any other institution identified in national legislation, it must be done in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. It is therefore submitted that the exclusion will therefore constitute a possible contravention of Section 217 of the Constitution. If we look at governance and accountability, it is submitted that it is not correct that the NHI Fund be authorized to investigate complaints against itself. Clause 13 makes provision for the Minister to appoint the board of the fund as well as the chairperson of the fund. In terms of Clause 13.3, an ad hoc advisory panel appointed by the Minister must conduct public interviews of shortlisted candidates and forward their recommendations to the Minister for approval. There is no provision for the criteria which the Minister will have to apply to appoint the ad hoc advisory panel. Section 2 and Section 44.4 of the Constitution state that in exercising its legislative authority, Parliament must act in accordance with and within the limits of the Constitution, and the supremacy of the Constitution requires that the obligations imposed by it must be fulfilled. The beneficiary is particularly vulnerable to or at the mercy of a fiduciary holding the discretion of all power. It is submitted that these clauses fall short from a government's perspective. On the infringement of a provincial responsibility, the bill does not allow for provinces to purchase healthcare services. It significantly reduces the powers and responsibilities of provinces as set out in the Constitution, the National Health Act, and the PFMA. Excuse me. A single purchaser payer provision of a bill infringes on the constitutionally mandated responsibility of provinces to ensure the progressive realization of the rights of access to healthcare services as set out in Chapter 4 of the Constitution. Section 44.1A2 and Section 104.1B1 of the Constitution vest concurrent legislative authority in Parliament and provincial legislature over the area of health services. Since the bill seeks to change some of the functions confirmed on provinces in terms of the National Health Act, by removing certain functions currently performed by the Provincial Department of Health, this will have the effect of removing the authority of provinces and may be unconstitutional. On medical schemes, the bill is silent on details on how medical schemes will operate once the bill is enacted. It is furthermore not clear how current medical schemes will access healthcare services during the phased implementation of the bill. The consequences of curtailing and limiting the services offering by medical schemes has the potential to undermine the stability of existing medical schemes market. Although the bill may not be compelling a person to become a user of an NHI scheme, by making payment of contributions to the fund mandatory, it's endeavors to emphasize the population to join the fund in order to gain access to needed healthcare services that will not be available from alternative sources such as medical schemes. Limiting people from purchasing medical scheme coverage they seek may seriously curtail the healthcare they expect and demand. It poses the risk of eroding sentiment and of denying the country of critical need skills. Ultimately, by preventing those who can afford it from using their medical scheme cover and forcing them into the NHI system, this approach may have the effect of increasing the burden on the NHI and will drain the very resources that must be used for people in most need. Because the bill is silent on the role of medical schemes and how it will access healthcare services during the implementation of the bill, this creates legal uncertainty. Problematic provisions of a bill, the language of a bill as it currently stands, creates legal uncertainty, contrary to the principle of the rule of law, which is founding value of the Constitution to be found in Section 1 of the Constitution. The rule of law requires that laws must be clear and accessible. A law that does not indicate with reasonable certainty to those who are bound by it what is required of them so that they may regulate their conduct accordingly is vague and accordingly unconstitutional and invalid. Public participation, Section 59 and 72 of the Constitution compel Parliament to facilitate public involvement in its legislative and other processes. Our courts have rejected the argument that the public need to participate in the legislative process as its elected representatives are speaking on the public's behalf. It is therefore recommended that the Portfolio Committee on Health should, in the thematic report on the report on the exact numbers for and against the proposed NHI bill, and if necessary, have the necessary supporting documentation available for scrutiny by all members of the committee. In conclusion, for the reasons as set out this morning, it is recommended from the point of proper compliance with the concept of a public participation that the thematic report indicates the exact number of comments for and against the proposed NHI bill. It is the opinion of this firm that the bill as it stands and without addressing some of the pertinent constitutional issues and concerns raised with reference to the achievement of the progressive realization of a right to access to healthcare services as provided for in Section 27 of the Constitution, the perceived limitation of existing rights of private medical aid members, foreigners and children will not pass constitutional muster and may in fact have the opposite effect than initially intended, in that it may frustrate, impede on and limit existing access to healthcare of many citizens, children and foreigners. It is submitted that if current medical scheme users suffers a reduction in access to healthcare as a result of a full implementation of NHI, this will give rise to a constitutional challenge based on violation of Section 27(1) to 2 of the Constitution. As demonstrated in the matter of Grootboom, and that there was a court case, legislative measures by themselves are not likely or sufficient to constitute constitutional compliance. The state is obliged to achieve the intended result as set out in the bill. In compliance with the Constitution, and legislative measures will invariably have to be supported by appropriate, well-directed policies and programs implemented by the executive, which must be reasonable both in their conception and implementation. Without funding the legislative measures as envisaged by the bill, as well as any well-directed policies and programs, will not constitute constitutional compliance with Section 27 and may in fact achieve the opposite by negatively impacting on existing rights. Instead of implementing the bill, the focus should be on strengthening existing capacity in the public health system by progressively achieving access to healthcare services in terms of existing means. There are serious and legitimate concerns raised from various participants on the issue of governance as well. The proposed structure intending to deal with the NHI fund, and these issues need to be addressed. Very real concerns arise from the current formulation. Yes,
How long
Chairperson.
still do you want to read it?
No, it's only 3 paragraphs. Thank you, Chair. Very real concerns arise from the current formulation of various clauses of the bill, and therefore non-compliance with the principle of the rule of law. The rule of law requires that laws must be clear and accessible. The bill does not indicate with reasonable certainty to those who will be bound by it what is required of them, so that they may regulate their conduct accordingly. Because the bill is vague, it will accordingly run the risk of being found unconstitutional and invalid. As stated before, and given the virus of the bill not achieving its objectives, the state could fail in its positive obligation, and if a bill results in reduced access to healthcare services, the state would also fail in its negative obligation, which will in turn give rise to constitutional challenge. The bill also faces severe constitutional challenges from a point of view of an infringement of constitutional rights of access to healthcare, as it currently undermines and negates the role of provinces and medical schemes to a great extent. It is the opinion of statutory attorneys that Parliament, in passing the proposed bill, would risk a constitutional challenge by interested and affected parties. I think it's it.
Thank you, Honorable van Staden. Would I assume that what you read when you said it is the opinion of Steyn and the partners, that you're saying that's the opinion of the Freedom Front Plus 2?
You are correct, Chairperson, because
Thank you.
we
Thank
are
you.
our legal team. Thank you.
Thank you for noting. Thank you. Honorable members, I had indicated that I will take political parties, meaning one member per political party, and I hope that the two political parties who have raised two hands will oblige with this ruling. I'm going to take Honorable Chirwa, then Honorable Sengwa, and then Honorable Gela. Thank you.
Thank you very much, Chairperson. We have made a submission to the Chairperson on the EFF's position on the clause-by-clause deliberation, which also have been partly touched by the state legal advisors in their previous presentation that we had to speak on. Since we are deliberating on it, we want to reiterate some sentiments that are encapsulated in that submission. The EFF is not in support of the NHI, particularly because it does not mirror our organizational aspirations of a socialist country, as would be the position of the economic freedom fighters. The NHI does not erase the two-tier system, as private hospitals will continue to function as private hospitals, and the state will then pay for their services on behalf of citizens. The NHI, in simple terms, is the outsourcing of public health care to the private sector. The NHI does not respond nor address to the inadequacies prevalent in private healthcare facilities, issues of human resource, EMS, expansion of specialists in the public sector, infrastructural inadequacies of public hospitals and clinics, and most importantly, the question that a health system that is focused on primary healthcare, prevention, and education is a reality. The NHI is merely the transference of elite community to be able to access private care that then the state pays for from one national pool of funding. Whilst in rural areas and townships, in destitute and remote areas and provinces remain confined to the very public healthcare that is dysfunctional. As for example, the referral system in the NHI Bill restrains people to their nearest healthcare facilities as the first point of reference. Furthermore, the profiteering priority of the private sector isn't addressed in the bill. Essentially, the EFF poses that all private hospitals be nationalized and one healthcare system be built without the inference of private care that prioritizes profiteering over healthcare and the well-being, and a government that outsources healthcare from the sector because of having failed in building a functional public healthcare sector. And clause number 5, we raised issues of registration and that it is exclusionary. The requirements of a house address and documentation relating to that, there is no clarity provided on what happens to children who are born to non-NHI users. There is no clarity on the issue of the proof of residence, as the bill fails to stipulate what occurs to persons who do not possess proof of residence. This is primarily a concern because millions of our people are confined in undignified informal settlements and subjected to homelessness. This clause therefore suggests an intolerance to persons affected to these effects. The bill fails to make an accommodation for South Africans who are also undocumented. And clause number 6.8, the requirement of proof of registration to fund or being registered user to the fund before accessing healthcare is exclusionary and non-constitutional, as it is against Section 27 of the Constitution. Nothing must keep people from accessing healthcare Time frame of registrations isn't stipulated. There isn't surety of this process being done diligently and efficiently either. There must be a provision for healthcare to still be accessible regardless of whether the person is registered or not. Failure to having registered as an NHI user is not the threshold for ensuring that people no longer have or possess the right to accessing healthcare, as is the requirement or as is what is stipulated by the bill inadvertently. Clause number 7.1.d is a limitation of possible health needs. A person can be referred to a primary healthcare facility, but that a person should first start there isn't always going to be possible or reality. Number one, there aren't primary facilities in all wards in the country. Some people are closer to hospitals than in clinics and GPs, and some illnesses are advanced quickly to allow room for firstly a primary facility first as the first point of contact. There is no room created for severe cases that do not have the liberty of following through the specific process. Some facilities aren't disability friendly infrastructurally and otherwise. Failure to provide subsection that clarifies what the situation should be in relation to an issue being an emergency is definitely a concern. 7.1.d3, what happens in the instance of abuse against the patient by a healthcare facility? Those are some of the questions that are not answered by the bill. A lack of referral shouldn't be an issue that results in a person not receiving access to healthcare. The clause fails to stipulate what occurs in the instance that a person is refused care in one facility and opts for another facility without having a referral letter. Referral system overburdens the sector, especially written referrals, termination of pregnancy, verbal referrals. When areas the bill requires an alternative, there must be a clarity on this that prevents people being turned away on this account and refused healthcare because they don't have referral letters. This is already the case and affects our people negatively, more especially women attempting to access their sexual and reproductive health rights. The referral system is currently abused in the public sector with attempt to avoid care for patients in the instance that a facility is overburdened. The bill is unclear on how unnecessary referral letters will be prevented that cause a delay in people accessing healthcare. 7.5.d, there is no provision for adequate reasons for refusal of healthcare. 7.6 doesn't suffice as a means to resolve the issue so long as the persons can't access alternative healthcare services at a different facility because of the referral system and awaiting outcome of lodged appeal. This is once again an imminent barrier in accessing healthcare as per need, which is cited as the primary foundation of the National Health Insurance Bill. Contrary, clause number 23.4 opens room for more corruption, which currently regresses the quality of public health care in the current dispensation. No apparent means to counter corruption threats. In the state legal law advisors stated in clause 3.5 be limited in wording to only affect the NHI to avoid anti-competitive behavior in relation to the amendment of the Completion Act. EFF rejects this entire clause, as much as we note the deliberation given by the state legal law advisors, because we have outlined the pro-private and anti-state sentiments of the NHI bill. This further prompts the dangers of the NHI and the vulnerability of the NHI fund, especially in the hands of the corrupt and thieving ANC government. Clause 26.2, lack of social expertise, social science expertise is also noted as a problem. Social, political, and economic aspects must be considered. Such expertise provides legitimate critique to limited view of science expertise. The expertise panel must include legal expertise, social health expertise, geographic health expertise, political health expertise, mainly because health issues, especially the monetary part, is more political than not. The minister should not have a representative in this committee at all, as undue supervision and exerted power over the numerous aspects of this bill is problematic and would limit the discussions and contributions if there is a constant eye and the voice from the minister's office that stifles the engagements. Costing issues are valid that we have raised even before. Possibility of these affecting the existing legislation also exists. Clause number 30, concern over this clause is that the ministerial power to the Minister of Health is undue. A minister cannot provide roles of overseer, implementer, terminator, all at once at his or her discretion. Clause number 31, the government of the day failed already on preventing wasteful expenditure, building administrative and technical muscle of the NHI, already chipping away the state's ability to cater for other primary needs that have to do with implementing primary mandate and obligation of the department. Establishment of these committees, the meetings that will be held, accommodation for committee deliberations are already problematic, as that is monetary value and muscle that could be utilized to build the state capacity of delivering basic health services, bettering infrastructure of existing health facilities, and increasing the workforce of the public healthcare facility. It is very intentional that the minister is given this much power, and it is purely political. That is what happens to the cabinet members and an executive that pledges loyalty to Bill Gates, who conceptualized step by step of how this NHI bill will be implemented, and overlooked Parliament and the deliberations that we have given clause by clause, and our role in oversight and holding the executive accountable in small print, as we see in such clauses as 31.b. 32 contradicts clause 31.2, which states minister is the one that will delegate roles and functions to provincial departments in the context of the NHI, despite that there's constitutional assertions and legislative assertions on this particular aspect. Second to this, there was an initial issue in the initial stages of deliberating on the bill on the role of provinces, and in fact, there have been contributions from provinces that have raised this concern of being ostracized and strict autonomy, noting that the fund is handled centrally. 32.2b is unclear on where the legal autonomy of hospitals begins and where it ends, how it will affect litigation process of the state against the NDOH. Furthermore, the bill is also unclear on the broader spectrum in relation to who carries the litigation costs of all hospitals, this including private hospitals. Clause number 33, medical insurance low-cost benefit option is wrongfully regulated by the Council of Medical Aid Schemes as it serves as insurance. The bill fails to make its depiction. This failure is analyzed as allegiance towards medical aid schemes, which are multi-billion industry. The clause and the bill in the entirety fails to make a deliberation on what happens to persons who choose to not register to be NHI users. Bill fails to clarify how unregistered persons will then access healthcare. Failure to register shouldn't be the reason to lose the right to accessing healthcare. Taking the money paid to medical aids and facilitating it as the state doesn't better the prospect of delivering sustainable healthcare. The money the government is aspiring for by taking away from medical aids currently fails to cater for the 10% of the population for an entire year, as is already. The bill suggests an integrated and one healthcare system, which is misleading as the private sector doesn't cease to function as a private facility. The retention of a two-tier system remains the case even with the NHI fully rolled out. Clause number 34 fails to stipulate that system unregistered users will then use to utilize access healthcare. This is primarily concerned as being registered as a primary requirement to accessing the fund and therefore accessing medical attention. There's no clear indication that the NHI will be an internalized system outsourced. The bill must clearly stipulate the relationship between the state or the relationship the state will have with the private sector as equivalent to the tendering system. The bill fails to outline how the transfer of existing data onto the new system will take place and what the new system will therefore be. The bill is also unclear on how capacity will be internally increased, noting the current backlogs and issues with state capacity of building and sustaining information systems. Implication of failure of registration of patients could possibly see the exclusion of medical intervention for patients, which is unconstitutional and has repercussions even for patients that are not registered as NHI users. The bill fails to outline on how unregistered users will purchase medication ordinarily purchased out of pocket or via medical aids. Unregistered users are not covered as per the bill in relation to medical purchases. This will impact access to medicine for unregistered users as well, which is unconstitutional. The bill fails to deliberate on what the funding alternative will be in the instance that the NHI pool of funds depletes. This clause number 35, releases government from the financial burden of the NHI, which is unacceptable, and it will be problematic in future when the fund can no longer cater for the health needs. And this clause is quoted in protection of this incapacity, more especially because incapacity can be caused by various reasons: mismanagement of funds, corruption, fraud, irregular expenditure. This clause serves as immunity for the state and not for the people, and is a financial threat even for the private sector that prioritizes profit and monetary gain at the center of their contribution to service delivery. This essentially means that the NHI fund, that in the event the NHI fund runs out, persons will be taken out from private facilities into public hospitals. It's the case when medical aids run out in the current modus operandi. This is a concern because the NHI has no intention of bettering public capacity and facilities, or increasing the workforce of the public sector, or bettering the current infrastructural crisis. What will then be the return time of deciding the level of emergency in the case that the fund has run out, and the waiting period must also be clearly deciphered, as this poses a threat of permanent and elongated waiting periods for service providers and suppliers, which may cost life in the case of private institutions who withhold services on account that the fund can no longer carry the financial cost. In the event that the fund cannot cater for the application emergency services required at a nearby private facility, the bill fails to stipulate what will be done in response to this. In the event the private facility treats the emergency and a decline of the services, the response from the fund, the bill fails to stipulate who will carry the financial cost of rejected claims from the private sector for provided services. This will compromise users and also suppliers. 35.4a, the bill is also unclear on what the system of reimbursing private emergency services once the cap has lapsed and will be, and who deciphers severity levels of this capping of funds stated in the bill. The private sector EMS is currently dysfunctional. The bill fails to outline the resuscitation of EMS services and what will be the primary EMS provision, private or public. Noting infrastructural inadequacies, medicinal shortages, lack of healthcare worker force in the public sector, what will be the systemic method of resolving these barriers to primary healthcare? The NHI overtly states no intentions of bettering the public health system with the interest of primary healthcare prevention and education. Prevention and education are married to primary health. However, the ANC government is satisfied with a curative system, and in-depth research and possibility of this being a reality is a requirement. District-based system is essential for any large project. The EFF made this recommendation to former Minister Zwelin Mkhize in the early days of the COVID pandemic, which was sadly only taken up late with minimal investment and accuracy in valid information. Capacity in South Africa is questionable on district-based systems. COVID pandemic highlighted the width of government in investing in this aspect. Minor issues like verification of information had no way of being proven, and there was no systemic bucket of evidence that we could peruse regarding the numbers we got on a daily basis on the burden of laboratories, and the burden of laboratories was evident and communicated. However, this did not lead to the government to devise a fully fledged system at district level. This will sadly be the case even with the NHI as well, as it was the case during the height of the global pandemic. The minister must explain this clause and appraise the committee on the kind of intervention they envision to see this being a reality on a technical, scientific, and managerial level, and how it will result in the guarantee of accessible and quality primary healthcare prevention and education, as is the obligation and mandate of the NDOH that has never been realized since 1994. Clause number 737 fails to outline the systemic numerical capacity of this unit. It fails to outline the day-to-day roles deciphered by the operational function of the unit. It fails to state accountability measures of the unit that is required by the NHI Bill on who the unit reports to and who supervises the day-to-day function. There's a subliminal procurement, coordination, and delivery that it is basically centralized in this unit, which will pose an issue to accountability. It highlights the overt tender system imminent in the bill, promoting tender systems that will only see the public purse being ensued and the health needs of our people being compromised or placed second. Building state capacity for permanent systems or needs that will permanently needed is the aspiration and the priority, and should be the priority of the government of the day. Outsourcing primary healthcare prevention and education is equivalent to the NDOH making an admission that they have failed in their primary mandate and obligation, which has always been the sentiment that the EFF has shared as the fundamental reason behind the NHI. This clause is evidence and admittance that the public healthcare sector has completely collapsed. Local and ward-based public facilities should be established immediately, infrastructure prioritized, increase of the workforce in the public sector, and the aspect of the NHI should have been directed to coordinating the quest towards these particular aspects. The private sector will never be a legitimate vanguard of the healthcare of our people. This bill is unclear on who facilitates the purchase of medicines, medical equipment, and other medical devices for persons, entities, health facilities, and other medical institutions who do not form part of the NHI's registered users and or service providers. The ability to participate in the industry cannot be taken away by failure of having registered or of not registered to be NHI suppliers or service providers. The impression given is that the NHI will be an encompassing system for all persons and institutions. But is it cognizant that choice will still suffice for registration processes and application processes of potential service providers and health facilities and even users? The bill is unclear on what happens when facilities don't register as service providers. The bill is unclear on who will regulate the relationship between these two, the registered and unregistered healthcare facilities. There's no clarity provided on the regulation of unregistered healthcare facilities. The bill is also unclear on what occurs when registrations and applications for service providers isn't seen through on the end of the mentioned and what becomes the default method.
Or Chirwa, just a short moment. I see that you're on the second section, but I had allowed you just for the sake of the other members to understand why I am now allowing more time. Because you are now already into the next section that we were going to deal with, and you're coming towards the end of that. So I'm going to allow you to finish it so that we're mindful that you'd already presented this when we go to the second part of our agenda, second item of our agenda. Thanks. It's for the other members to understand. Please continue.
In essence, the EFF continues to reject the NHI. I think that was you citing, but I must conclude it's still fine. The EFF does reject the NHI for the reasons that I stated above. And that remains the position of the economic freedom fighters. Thank you.
Thank you very much. Honorable Sengwa, are you there?
Thank you, Chairperson. Let me greet all the honorable members and you, Chairperson. First of all, the IFP, we as IFP have already submitted our input in this NHI. The IFP supports the bill because there are many people who are just down at the ground, who depend, who are suffering down there, have no money, nothing, depend on grants. Therefore, the NHI will assist them to get their medication, to get everything that is necessary for them. In our hospital, there are now, as we are speaking, hospital and clinics. We have ideal clinics where there are advanced medicine. As my clinic at home, we have an ideal clinic of which it is where if it's NHI implemented, it would be more and more assistant of the people. Because of these people depending on the grant, NHI is going to help many, many people. People who are most vulnerable is women and children. We know that women are the most vulnerable person in the world. Now they need this NHI. We as IFP, we don't want to block the freedom of our people to help. We don't want to do that. There is no work, no money. They really need the NHI. The really need of NHI bill is not a luxury, but it's a need. Our hospital will be furnished with equipment and medicine. That's the reality. Because when we go to an ideal clinic, we find this medicine. We find this essential medicine. That is the reality. If we pursued and passed this bill of NHI, our people is going to be free. Yes, there are high percentage of medical aid, but still there are many, many people who did not have, who depend on the government grants. Let us let them be free. NHI is going to do something better, something nurses are going to be safe. The files of our people is going to be safe because they are going to be electronic. The treatment is there, everything is there. Therefore, the IFP support NHI. Thank you.
Thank you, Honorable Slengwa. the last person on this topic before I do anything else afterwards on this particular matter. Honorable Gela.
Thank you very much, Honorable Chair. Honorable Chair, as African National Congress, we support the implementation of the NHI in this country. Chairperson, we have participated in the whole process as the ANC, and we have submitted our submission in writing, Chairperson. But as ANC members, we are rejecting the view contained in the legal opinion shared by Honorable currently, there are two parallel health subsystems in South Africa, the public and the private healthcare system. The private sector is better funded, but serves a
Honorable Gela,
Chairperson.
can you speak more into your microphone, please? Maybe just start again. Thank you.
I'm audible, Chair.
Now you
Can you
are
hear me?
better. Yes, it's better now. Thank you.
Okay, Chairperson. Chair, I'm saying as African National Congress, we support the implementation of the NHI Bill in this country, Chairperson. And Chair, we've participated as ANC in all processes since we started clause by clause, and we have submitted in writing, Chair. But Chair, coming to the issue of Honorable Van Staden, as ANC, we reject the view contained in the legal opinion that was shared by Honorable Van Staden, Chairperson. But Chair, also currently there are two parallel health systems in South Africa, the public and the private healthcare system. The private sector is better funded but serves a few people, which is 16% of the population, than the poorly funded public health, which is used by the majority of the population, Chairperson, which is 84% of the population. Unfortunately, the two systems are competitive rather than being complementary. The rich pool their funds separately from the poor, but both systems Chairperson compete for scarce resources. The health professionals, the rich are always able to pay more, so it is not a surprise than that they attract more resources to their care, relates to the poor. The subsequence of this, that those with the greatest health needs, mainly the poor, have the least access to services and subjected to long waiting times, deadly facility and bad staff attitude. This currently a structure of the health system is neither fair or just, as it favors rich people over the poor people. The private system spent 51% of the country's health spent in 2021, 277.402 billion, while the public sector spent 49%, which is 265.844 billion. Donors contribute further 11.995 billion, bringing total spend to 554.341 billion. This is a raw 8.5% of GDP, Chairperson. The problem is that this translates to 26,700 per capita spend on private patients per annum, and only 5,322 per capita per annum per public patients, including the public sector spend on a public health system for the both sectors. Chair, the funders adds an estimate of 15% to the cost of the private sector, most of which can be removed by NHI. Furthermore, Chair, both public and private sector duplicate a medical investigation and care for patients owed to failed integration. This adds cost, but also exposes patients to poor health care and possible danger, Chair. Access to quality health services is further determined by race, gender, and
Gela, can I please interject?
okay, Chair.
Honorable Gela, we are busy with the legal inputs on the legal opinions. Can I ask you to wrap that part up and just take something else, please? Because I do know that you said the ANC supports the implementation of the NHI Bill. Would you say that the ANC supports the NHI Bill and not the implementation of the bill, so that we understand from a legal perspective? Thank you.
Thank you very much, Chairperson. In summary, Chair, the ANC support the implementation of the NHI, and everyone has the right to have access to healthcare services, Chairperson. Thank you very much, Chair.
Thank you very much, Honorable Gela. Honorable members, we've now had these inputs. We have now had these inputs. I'm now going to the following stage. And that is that we've considered various legal opinions and views on the clauses of the NHI Bill. I want to ascertain whether the majority of the members of this committee supports the view that the bill is constitutional and that the bill is acceptable, and that they actually support the bill with the amendments which might be raised, which had been raised in terms of the submissions, both written and orally here today, and that we will be doing again when we do the clause by clause discussions hereafter. So I need to get a clear indication of the support for the bill by the political parties. And I would ask that you only stick to what I am asking you to do. Honorable Kaba.
Thanks, Chair. Chair, may I indicate that, Chair, the ANC wish to make it clear that we reject the views as contained in the legal opinion shared by Honorable Staden, as reflected by Honorable Gela, and rise to support Honorable Gela on having made it clear that the ANC had submitted its input. And Chair, we are only not doing so because we are happy. We are doing so also to remind the people of South Africa that today, 29 years ago, Nelson Mandela was also inaugurated for freedom of all of us, for freedom of all of us to also receive better health. As a result of that, ANC is in support of the NHI Bill, and Chair, we are ready to proceed to raise with you on other matters which are necessary on the legal opinion on clause by clause. Thank you, Chair.
Thank you very much, Honorable Kaba. So, honorable members, I would like to hear Honorable Howard and Honorable Hazel so that I could be able to make a final statement on what we have just done. Honorable Harvard.
Thank you, Honorable Chair. As the opposite party stated, and also our member, Honorable Gela, and also Honorable Kaba stated, from my opinion, as ANC, I fully support the completed NHI bill because that is on behalf of our majority benefit. Thank you, Chair.
Thank you. I take Honorable North-Nafel, then I'll take Honorable Wilson, who switched on the microphone, camera, and raised their hand.
Thank you, Chair. I also support Comrade Harvard, Honorable Harvard, Honorable Jela, and Honorable Kaba in this bill, because our country and our people also need it. So I'm in full support of the bill. Thank you.
Thank you. So, honorable members, without us now being provoked, I'm going to take the 3 hands for short statements, please. No long statements. I see you raised your hands because we're going to end this part. It's very short, Honorable Wilson, Honorable Van Staden, Honorable Clark, because now you're provoked by what has been said by the others. Honorable Wilson, in that order, Van Staden and Clark.
Chairperson, you asked for our opinions. The Honourable Clark has said that the DA is rejecting the bill. The health is broken already, and this will only exacerbate the system and make people, the poor people, more vulnerable. So I will support the Honourable Clark. Thank you.
Thank you, Honourable Van Staden.
Thank you, Honourable Chairperson. As also stated last year in May, when we voted on this bill before we started, I just want to put on record that the Freedom Front Plus rejects the NHI bill in its entirety. Thank you very much.
Thank you, Honourable Clark.
Thank you, Chairperson. Just to reiterate that the DA completely rejects this bill in its entirety. Thank you.
Thank you, Honourable Chirwa.
Thank you, Chairperson. The EFF rejects the NHI bill in completion. Thank you very much.
Thank you very much. Honourable members, what that means is that there are 4 members who reject the bill, and there are following members who support the bill. It's Gela, Kaba, Harvard, North-Nafel, Honourable Slengwa, and myself. I also support the bill, considering that there will be amendments which will be made in the closed deliberations. Thank you very much for everyone for fruitful discussions on the first part of our work. I will immediately go to the second part of our work for today, honourable members, which is on the clause-by-clause deliberations on the NHI bill. It's also noted that, yes, let me stop at that. So, clause-by-clause deliberations. We would be reminded that throughout the deliberations on this bill, members have been requested to submit written proposals for amendments. Written submissions were received by the committee from the ANC, EFF, IFP, Freedom Front Plus, and the department. The submissions were presented by members throughout the deliberations and shared with all members, the department, and the legal teams. We have come to the stage in the processing of the bill where members of the committee have an opportunity to propose amendments for insertion in an A list. Before we consider these, I want to request that the Parliamentary Legal Services records, drafts, and presents accurately the amendments which will be proposed by members today. I'm going to repeat that one. Before we consider these, I want to request that the Parliamentary Legal Services records, drafts, and presents accurately the amendments which will be proposed by members today. The department's legal people and the state law advisors must also record the amendments proposed and ensure that the A list drafted by the Parliamentary Legal Services is accurate and drafted correctly before it is presented to us Friday. We have scheduled a meeting on Friday, the 12th of May, 2023, when the Parliamentary Legal Services will present the A list to us. I want to remind us on the NHI Bill that, and I had said it earlier, that the department had in November 2022 also submitted proposals for amendments to the bill. So when I also note the request of Honorable Van Staden for a 5 minutes comfort break. When we come back, I will open the floor for members to discuss what to do. Firstly, about the department's proposals, and secondly, members to respond and say that as members they want the department's proposals included in the A list or not, and also give any indication of any amendments, deletions, or changes which the members would want to make to the NHI bill. So, honorable members, we will take a 5 minutes break. It is now 10:47, so we will be back at 8 minutes to. Thank you very much. Do not switch on your devices. Do not switch off your devices, and we will be back at 8 minutes to 12, 8 minutes to 11. Thank you. Honorable members, we are back. I have indicated what it is that we will do in this section. I would just want to ascertain whether the state law advisors, the legal services of the department, and the parliamentary legal services have taken note of what I have just ruled on. So I'd like to hear from them that they have taken cognizance of what I had stated, and the fact that they would have to come, when we had completed this work, they would have to come and present the A-list to us on Friday. Ms. Ann Isaac?
Sorry, so yes, I have taken note of your instruction, Chairperson.
Thank you. Advocate Johar and Advocate Tiernison.
Good morning, Chairperson. I acknowledge the instruction.
Hercules, sorry. Sorry, my apology, Hercules. Yes, Theo and Tiernison got me a bit messed up there. Yes, Honorable Advocate Johar.
Thank you, Chairperson. We acknowledge the instruction and we'll do our part to assist the parliamentary law advisors. Thank you.
Thank you very much. The department.
Good morning, Chairperson. We have acknowledged your instruction. We will assist the parliamentary legal services. Thank you, sir.
Thank you very much. So, honorable members, we will go on to the next section of our work, which is on the clause by clause on the NHI Bill, not deliberations. We had completed our deliberations. I'm going to state what the procedure will be, and it will be basically that I would simply mention the long title, and I would ask if there's any political party which wishes to make an amendment to that section. I would then go on to the preamble. I would simply say preamble, and we would then move on. Once we have completed that, any political party to give any input, we will then go on to clause 1, and we'll go like that, clause by clause. I'm not going to read the clauses. I'm also not at the end of this discussion going to read what the political party's input had been. That is why I've made it very clear that those 3 legal services, legal advisor services, would have to take good notes, has to, and after each one is read, I'm going to ask them whether they had recorded it and whether they are happy with whatever they had recorded, and we will finish this work today, honorable members. You would know that these are many pages. After we had completed with the clauses, we'll go to the schedules, and then we hopefully will finish this by 1 o'clock today. I see Honorable Temba Kwayo, you have raised your hand, and honorable members, after Honorable Temba Kwayo, we go straight into the clause by clause deliberations. Thank you.
Thank you, Chairperson, for this opportunity. I just want to ask to say, but what is the purpose of what we are doing right now? Because we have presented now, and immediately thereafter, we are supposed to go back and do. Why can't we give the Secretariat to capture what we have presented now, so that whatever we have presented is, if it's possible, captured into this NHI thing, and then it's then that you can come with this practice. We have just presented now.
Well,
that's my thinking.
Yes.
That's
now let me answer you. So, Honorable Dr. Temba Kwayo, what we are doing is we're following the process as stipulated. I have been made absolutely certain that we follow the due processes, and this is part of the due processes, that we're going to go through this clause by clause, and I'm going to ask political parties on a particular clause, the clause that is called for, to give their final inputs, because these are the final inputs which are now being requested, which will be captured in the manner that it is put forward by the political parties and will be captured by the legal services, which I had mentioned, which would then be captured in the A list, and we will come back and we will discuss that. That would be your opportunity to see whether your inputs have been captured in the manner that you thought it ought to be captured. I just need to remind yourselves that there are 3 political parties which had stated that they reject the bill. And the DA, for example, by the words of Honorable Clark, said we're not recommending any amendments. The Freedom Front Plus, the words of Honorable Van Staden, said that they are not that they don't support the NHI bill. The EFF said, the words of Honorable Chirwa, that they do not support the bill. The ANC said that they do support the bill, and the IFP, by the words of Honorable Shengwa, said that they do support the bill. That's where we stand now, honorable members. Let us please continue. So, on the preamble, honorable members, I will ask for any political parties which to want to make any amendments, suggest anything different to what is written in the bill, the preamble of the bill. I will take hands. Is that still a legacy and Honorable Tembekwayo?
Sorry, Chair, let me lower the hand.
Thank you. Thank you. Honorable Gela.
Thank you very much, Chairperson. Chair, on the preamble, ANC support the preamble, Chairperson. ANC doesn't have amendment to clause, the first clause, which is the preamble. We support it, Chair.
Thank you, Honorable Van Staden.
Chairperson, the Freedom Front Plus rejects.
Thank you, Honorable Clark.
Thank you, Chairperson. The DA rejects.
Honorable Clark, we lost you.
Sorry, Chairperson, can you hear me now?
Can hear you now.
Thank you. The DA rejects.
Thank you. Honorable Dr. Susan Tembekwayo.
Thank you, Chairperson. The EFF rejects, and if we got cut by the network, we are rejecting all the clauses. So register it like that. Thank you.
Thank you. Honorable members, thank you very much for your input. We will go to clause 1, the definitions.
Chair, I thought I raised my hand.
Yes, your hand is raised. Sorry, Honorable Kaba.
No, Chair, I think Honorable Gela had said it correctly on the preamble. We are fine. I support what Honorable Gela raised. Thank you.
Thank you. All right, honorable members, so would I then assume that the ANC supports the preamble as is, as it is contained in the bill?
Yes, Chair.
Thank you, all members of the ANC. Thank you. I think, honorable members, what we ought to do also is the following. We will follow the procedures which are used in the National Assembly in order to make this easier. Otherwise, I would have to ask this question consistently. we would then presume the following, that when a member, and in this case, Honorable Gela speaks on behalf of the ANC, I would assume that all of the ANC members support that view, because we'd have to be able to capture a majority decision with every clause. I would then also assume that the members of the other parties who had raised that they do not support the bill would then be opposing that. If there's and that the member of the IFP would support what is raised in the discussions. I think that's going to be a much easier way for us to understand what it is that we are doing. And if there's anyone who wishes to abstain or refrain from the decision that is put forward, or the amendment that is put forward by a particular political party, then that member needs to raise her or her hand on the platform and indicate that he or she wishes to do that. I think that's the rule that we are going to apply, the same rule that we apply in the National Assembly. So I will now go to clause 1, definitions. Any members? Honorable Clerk.
Thank you, Chairperson. The DA rejects.
Honorable Van Staden.
Freedom Front Plus rejects, Chair.
Thank you. Honorable Gela.
Thank you very much, Chairperson. I'm on load shedding. If you can allow me to switch off my camera, Chair.
Certainly, Honorable Gela, but not for the entire meeting, in between. Thank you. We still need to see your face. Please continue, Honorable Gela.
Thank you, Chairperson. Chairperson, the African National Congress support the definition, Chairperson, but we are also having this proposal, Chairperson, on amendment, maybe the addition to the definition. The following definition to be included in the bill, Chair. Supplier means a natural or a juristic person in the public or private sector providing goods and services other than personal health services. On health product, Chair, ANC is submitting that health products means a product regulated in terms of the Medicines and Related Substance Act, Act 101 of 1965, of the Hazardous Substance Act 15 of 1973, the food stuffs, cosmetics, and Disinfections Act 54 of 1972, and or any other product, medical device or medical equipment regulated by a law governing its quality, efficacy, or performance and supply, or product used within the provision of the healthcare service. On basic health care services, this is our edition, Chair, as African National Congress. Basic health care services are defined as those services provided by a primary health care providers, which are essentially for maintaining a good health and preventing serious health problems. These may include preventive services, primary health care, emergency care, including immediately medical attention for life threatening injuries or illnesses, diagnostic services, treatment services, rehabilitation services. On conditional accreditation, Chair, ANC submit that Chairperson, conditional accreditation means that status granted by the NHI fund to a healthcare service provider or a health establishment that partially meets their requirement for full accreditation and requires a need for a significant action in order to be fully compliant with accreditation requirements. Granted a certificate, Chairperson, as ANC means our submission, Chair, means a process that the Office of the Health Standard Compliance uses the classified performance of the health establishment as excellent, good, satisfactory, or unsatisfactory, that is based on essential vital measures and essential non-negotiable measures to conditions, processes and practices that are necessary to provide safe, decent and quality care. On reasonable opportunity, Chair, our submission as ANC is that it means that all decision and ensuring action must meet the rationality test and must be fit for purpose. Lastly, Chair, on a reasonable period of time, as ANC, this is our submission to that refers to the amount of time that is fairly required to do whatever is required to be done and conveniently under the permitted circumstances. That will be our submission as African National Congress in this first clause, which is the definition. If Chair can be added, thank you very much.
Thank you very much. Honorable, is there any other hand? I had seen a hand which has now been lowered again. So I'm going to assume that what had been raised by Honorable Gela is supported by all the members of the ANC. I'm going to the next section, Honorable members, which is Clause 2, title purpose of the Act. Is there any amendments being proposed to this clause? I'm going to take the hand of Honorable Tembakwayo, followed by Honorable Van Staden, Honorable Clark, Honorable Nothnagel, in that order.
Thank you, Chair. Like I indicated before to say, I don't think there's even a need for us to keep on raising hands here. Just note that all the clauses as they are in the present situation are not are rejected. We reject it. So we have network problems here. So it's an issue. We have made our submissions. Those that are supposed to take our submissions and make the amendment, let them do that. Thank you.
Thank you. Noted, Honorable Tembakwayo. I'm going to assume then that you're not going to raise your hand again, that you're just rejecting all of the clauses. And also, let me just ask you also on the schedules, or will you come to that later? Honorable Van Staden.
Okay, Chairperson, the Freedom Front Plus rejects.
Thank you, Honorable Clark.
Thank you, Chairperson. The DA rejects.
Thank you, Honorable Nothnagel.
Thank you, Chair. We've got nothing to add to this purpose of the Act. We're fine with it. Thank you.
So Honorable North Narkle, am I assuming the ANC supports the clause 2 as it is contained in the bill? Is that what you're saying?
Yes, yes, Chairperson, we accept it as is. Thank you.
Thank you. Clause 3, Honorable Clause 3, which is application of Act. Anybody wishes to make any amendments? Honorable Van Staden,
Freedom from plus rejects, Chairperson.
Honorable Clark,
The DA rejects, Chairperson.
thank you. Any other hands? Any other hands? Honorable North Narkle.
Thank you, Chair. We would just like to do a proposed amendment on clause 3.5. If it can be amended in the following manner: the fund must be exempted from the provision of the Competition Act 1998, in brackets Act number 89 of 1998. Then the next part must be deleted, is not applicable to any transactions concluded in terms of this Act, and then to be exchanged with the following: to enable it to fulfill its mandate as a single purchaser and single payer as contained in clause 2A of the bill. Thank you.
Thank you. So what I am reading, you're saying, Honorable Narkle, is that clause 3.5 amended should read as follows: the fund must be exempted from the provision of the Competition Act 1998, which is Act 89 of 1998, to enable it to fulfill its mandate as a single purchaser and single payer as contained in clause 2A of the bill. Are you wanting to say anything about the other clauses, sub-clauses? You've taken out 5.
No,
the ANC support the rest of the other clauses as they are contained.
Yes, thank you, Chairperson.
Thank you very much. Honorable Gela.
Thank you very much, Chair. I rise to support Honorable G9 on his submission as African National Congress. And also, Chair, if you can just note Honorable Hlengwa.
Yes, you're correct. So, Honorable Hlengwa, I would also then presume that you're supporting the amendments which are being proposed.
Thank you, Honorable Chairperson. I fully support.
All of the amendments which will be proposed.
Yes.
Thank you. Thank you, Honorable Hlengwa. So, honorable members, I had given an indication that all members of a party which present amendments would be recognized as supporting those amendments unless they indicate to the contrary. So you don't have to repeat and support one another. If it's raised by a member of a particular political party, the presumption is that the entire party, as we do in the National Assembly, supports that view. So we will go to clause 4. Population coverage. Any inputs? Honorable Van Staden.
Chairperson, the Freedom Front plus rejects.
Followed by Honorable. Thank you. Followed by Honorable Kaba.
Chairperson, thank you. The ANC on clause 4 would like propose the following amendments. On clause 4.3 as follows: we replace the term illegal migrant with the illegal foreigner. This has to be consistent with the provision of the Refugees Act to read as follows, Chair, very key: all children, including children of asylum seekers or illegal foreigners, are entitled to basic healthcare services as provided for in section 28.1.c of the Constitution. Thank you, Chair.
Thank you. Any other sub-clause in the clause, Honorable Kama?
Chair, I think that was that on clause 4, Chair. Thank you.
So I'm not going to read all of this every time, honorable members. I'm going to just read it now for clarity. When any of the members say we want to bring an amendment to this sub-clause, they should just please indicate the other clauses, that they agree with the other clauses as it stands in the bill. I would want you to say that. So I'm going to read this one and we move on. So you are saying that you want an amendment to clause 4.3 as follows: replace the term illegal migrant with illegal foreigner to be consistent with the provisions of the Refugees Act. And that so the word migrant also becomes foreigners. Thank you very much. And that the other sub-clauses is supported by the ANC as it stands currently in the NHI Bill. Honorable Clerk.
Thank you, Chairperson. The DA rejects.
Thank you. Clause 5. Honourable Sardin and Clark.
Chairperson, the freedom from class rejects.
Thank you, Chairperson. The DA rejects.
Thank you. Any other member? Honourable Harvard.
Thank you, Chair. For clause 5, sub-clause 1, 2, 3, 4, 5, 6, ANC support, just keep as it is. For clause 5, sub-clause 7, ANC has the following amendments. Clause 5A, to replace the term proof of registration to proof of identity, and to read as follows. 5.8, a user seeking healthcare services purchased for his or her benefit by the fund from accredited healthcare service provider or health establishment must register where after the user must present proof of identity to that healthcare service provider or health establishment when seeking those healthcare services. This is clause 5, subclause 8. Sorry, I forgot clause 5, subclause 7. Must change the word uncredited to credited. Thank you, Chair.
Thank you for making it so clear, Honourable Harvard. Just for noting, Honourable members, there was a request from the Legal Services Parliament that these be forwarded to them in writing. So there will be an undertaking from that, because it's going to be quite difficult for them to capture every word as it is being read. So we will ensure that that is forwarded to them in writing, not later than today. On clause 6, rights of users, honourable members. Started.
Chairperson, the freedom from class rejects.
Thank you, Honourable Clark.
Chairperson, the DA rejects.
Thank you, Honourable Noosnagel.
Thank you, Chair. On point 6, the first part, we would like to amend the following. Clause 6 to be amended through deletion and to read as follows. Without derogating from any other right or entitlement granted under this Act or under any other law, a user of healthcare services purchased by the fund is entitled. And then within the state available and appropriate resources, that part must be deleted. Then I also would like to say the following 6A, B, C, D, E, F, G, H, I, J, K, L, M, and N, there would be none. We accept that as it is. And then O, the proposed amendment would be at clause 6O, would read as follows: to purchase healthcare services that are not covered by the fund through a complementary voluntary medical insurance scheme registered in terms of the Medical Schemes Act. Private insurance covering an international traveler with short-term or work or student visa, and then delete any other private health insurance scheme and stop there to delete, and then accept all out-of-pocket payments as the case may be. I thank you, Chairperson.
Thank you, Honourable Knopfler. We're going to clause 7, healthcare services coverage. Honourable Clark, Honourable Staden, Honourable Kaba.
Thank you, Chairperson. The DA rejects.
Thank you.
Thank you, Chairperson. The Freedom from Plus rejects.
Honourable Kaba.
Thank you, Chair. The ANC on clause 7, Chair, we would like to indicate that we are keeping it as it is, except we are proposing the amendment on clause 7.2 on F and I, that it should read that saying, the minister, in consultation with the Minister of Public Service and Administration, must, by regulation, designate central hospitals as national government components in accordance with Section 7.5 of the Public Service Act, 1994, Proclamation number 103 of 1994. Therefore, Chair, as entirely with that amendment, clause 7, the ANC proposes that it stays as it is with that only amendment. Thank you, Chair.
Thank you. Clause 8, cost coverage. Honourable Staden,
The Freedom from Plus rejects, Chair.
Honourable Clark,
The DA rejects. Thank you.
Honourable Kaba.
Thanks, Chair. Chair, on cost coverage, clause 8, we wish to propose the following amendment. In particular, 8.2.a. 8.1 is right, Chair. That to be amended as follows. A person or a user, as the case may be, must pay for healthcare services rendered directly or through a voluntary medical scheme registered under the Medical Schemes Act, or through a private insurance covering an international traveler with short-term or work or visa out-of-pocket payment. We wish to indicate that we delete or any other private insurance scheme. That's my submission. But B, Chair, continue to propose that the deletion on clause 8.2.b should be deleted completely. What are we deleting here? We are deleting that fails to comply with referral pathways prescribed by healthcare service provider or health establishment. That's what we are proposing as a deletion. Further proposing amendment on 8C, 8.2.c to be amendment to be read as 6 services that are not deemed medically necessary by the Benefits Advisory Committee, or that are not covered by the fund as promulgated in regulations approved by the minister. Lastly, Chair, to indicate also that the amendment we are proposing on clause 8.2.d, we must delete the word formulary. Replace it with comprehensive set of healthcare services as devised by the Benefits Advisory Committee. Therefore, revised clause 8.2.d amended to read 6, that it is not included in the comprehensive set of healthcare services as advised by the Benefits Advisory Committee treatment. Thank you, Chair. That will be our submission as ANC on clause 8.
Chair, your sound is off.
Oh, sorry, I'm muted. Chapter 3, Health Insurance Fund, clause 9, establishment of the fund. Any hands? Honorable van Staden, Clark, and Geller.
Chairperson, the Freedom Front Plus rejects.
Chairperson, the DA rejects.
Chairperson, ANC support clause 9, no amendment, Chair.
Thank you.
Chairperson, the IFP support.
Thank you very much, Honorable Sengwa.
Yes.
Clause 10, functions of fund. Honorable van Staden.
The Freedom Front Plus rejects, Chair.
Thank you, Honorable Geller.
Thank you very much, Chairperson. ANC support the clause from A until the last clause, Chair, of this clause 10, Chairperson. We support the whole thing, Chairperson.
Thank you, Honorable SEs, Honorable Geller, Honorable Clark, followed by Honorable Sengwa.
Thank you, Chairperson. The DA rejects.
Thank you, Honorable Sengwa. Honorable Sengwa, you had indicated earlier will support all amendments proposed. So we will go to clause 11, powers of the fund. Take hands, honorable members, Honorable Staden, Honorable Clark, and then Honorable Kaba.
The Freedom Front Plus rejects, Chairperson.
Thank you.
The DA rejects, Chairperson.
Thank you. Honorable Kaba. Honorable members, I'm not going to call every day. When I call the order, please respond. We have a lot of work to do.
Thank you, Chair. Chair, on clause 11, as ANC, as with previous, the amendments we stand to support as raised by all other members of the ANC. Chair, on clause level 1, on clause level 1A up to H, the ANC proposes that it remains as it is. However, wishes to propose an amendment on 1I, on clause 11, on 1I. The amendment is proposed as follows. Clause 11, 1, 4, to be amended as follows. Receiving and collating of all required data from healthcare service providers, healthcare establishment and suppliers for the efficient running of the fund. That is amendment we are proposing there on I. And Chair, wish to indicate that on clause 1J, K, up to O, it remains as does, and up to 2E, it remains as does on clause 11, Chair. That is our proposal as the African National Congress, Chair. Thank you.
Thank you. Honorable Sengwa, shall we stay with it? Want to make sure. I'm going to again indicate that on the same word, confirm that she supports all amendments raised by the African National Congress. Thank you. Chapter 4, establish and clause 12, establishment of board. Honorable Van Staden.
Freedom from class rejects, Chairperson.
Honorable Northnagel. Honorable Northnagel, you're muted.
Sorry, Chair. There's no amendments on this clause from the ANC. Thank you.
Thank you. Honorable Clark.
Thank you, Chairperson. The DA rejects.
Thank you. On clause 13, constitution and composition of board. Any proposals or amendments, honorable members? Honorable Clark, Van Staden, and Northnagel.
The DA rejects.
Freedom from class rejects, Chair.
Thank you. Honorable Northnagel.
Thank you, Chair. On 13.1 and 2, there's no amendments, but then 13.3, the proposed amendment must be forward. It's on 3B. Forward the recommendations to the Minister for an approval by Cabinet. That's the amendment. Then on 4, there's no amendments. On 5, clause 13.5, it must be amended to insert F as follows. The composition of the board must broadly reflect
Honorable Northnagel.
We cannot hear, Chair.
Yes, Honorable Northnagel. Is there any other member of the ANC who wishes to?
Chairperson, I think I lost.
Yes. Can you start again?
Whenever a
with-
position on the board becomes vacant before the expiry of the term of office, the Minister may appoint any other competent person who meets the criteria listed in section 3.5 of the Act to serve for the unexpired portion of the term of office of the previous member, irrespective of when the vacancy occurs. Then 6, 7, and 8, there's no amendments. But then 9, I've got the following to be amended with the following insertion and deletion. Add to 9A, subject to paragraph B, the Minister may dissolve the board and then only after inquiry and approval by Cabinet. Then there's a deletion, A1 in brackets, this must be deleted, giving the board a reasonable opportunity to make representations, and small 2, affording the board a hearing on any representations received. So that must be deleted. And yeah, that's my recommendations. Thank you.
Thank you. Honorable Northnagel, just something that I think you didn't mention correctly. Clause 13.3b. Is that where you wanted to put the part, the following amendment, forward the recommendations to the Minister for approval by Cabinet?
Yes. Yeah. Only
Thank
after
you.
inquiry approval by Cabinet. Thank you.
Thank you. Clause 14, honorable members.
Chair.
Yes, Honorable Gela. Yes.
Before you move, Chair, because Honorable Northnagel was struggling with the connection, if maybe she can repeat clause 13.5 F. I didn't hear Honorable Northnagel on that one, Chairperson. I will request that.
Can you oblige us?
Yes. Yes, I was disconnected. So clause 13.5 to be amended to insert F as follows. So it's 5F. Composition of the board must broadly reflect the diversity of the country, including in relation to age, race, gender, and disability. Also to be further enhanced to include the following provision. 5G. Whenever a position on the board becomes vacant before the expiry of the term of office, the minister may appoint any other competent person who meets the criteria listed in section 13.5 of the Act to serve for the unexpired portion of the term of office of the previous member, irrespective of when the vacancy occurs. Thank you.
Thank you. Honorable members, we're going to clause 14, chairperson and deputy chairperson. Any amendments proposed? Any Honorable van Staden?
Bevriending van Plus rejects, Chair.
Honorable Clark?
Thank you, Chairperson. The DA rejects.
Honorable Kaba? Honorable Kaba? Honorable
Yes,
Kaba?
yes, Chair, I'm here. Chair, I'm saying, Chair, on the chairperson and the deputy chairperson, the ANC proposed an amendment on clause 14.1 to be amended with the following addition: that the minister must, after consultation with the cabinet, appoint a chairperson from amongst the members of the board as contemplated in section 13.1. Thank you, Chair.
Thank you. You're saying that clause 14, subclauses 2 and 3 remain as they are?
Yes, Chair.
Thank you.
Yes, Chair.
Clause 15, functions and powers of the board. Honorable van Staden, Honorable Clark, followed by Honorable Kaba.
Bevriending van Plus rejects, Chair.
Thank you.
The DA rejects, Chair.
Thank you.
Chair, ANC on function and powers of the board on clause 15 proposes that, Chair, clause 15.2 propose the following amendment. Clause 15.2 must be enhanced at the end of the sentence with the following, Chair: that the quorum of the board will be the majority of the total number of board members present, and the board will make the binding decisions by a majority of members present at the meeting, provided that the quorum is attained from number present. If there is a tie, the chairperson will cast the deciding vote. That is the enhancement we are proposing as the ANC. That, Chair, clause 15.3 to be amended to read: the board must advise the minister on any matter concerning, we will delete the management and administration of fund, including operational, and replace it with financial and administration policies of the fund. I'll repeat this one. Clause 15.3 to be amended to read that the board must advise the minister on any matter concerning financial administrative policies of the fund. And then on clause 15.3 F to be enhanced to read collective bargaining and employment terms and conditions. Clause 15 to further be enhanced to include a new subclause to read on 15.5, the board and the CEO of the fund must meet with the Minister and Director General of Health at least twice per year in order to exchange information necessary for the board to carry out its responsibilities. That's our proposal as ANC, and amendments and the deletion and the insertion and enhancements on clause 15, Chair. Thank you.
Thank you. Clause 16, conduct and disclosure of interest. Honorable van Staden.
Bevriending van Plus rejects, Chairperson.
Honorable Clark.
The DA rejects. Thank you.
Honorable Kaba, I'm assuming you haven't lowered your hand. Honorable Gela, can you speak?
No, that's a legacy and Chair.
Yeah, please remove your hands, honorable members, when you are done. Thank you.
It's a legacy hand. Thank you very much, Chairperson. Chair, on clause 16, ANC support clause 16, 2, 1. Chair, I want to make a submission on clause 16, 2B, to be amended to read as follows, Chair. Attend, participate in, vote or influence in the proceedings during a meeting of the board or of a committee. Therefore, if in relation to the matter before the board or committee that a member has an interest, including a financial interest and or indirect material interest that precludes him or her from acting in a fair, unbiased, and proper manner. Or, Chair, I want us to amend, African National Congress want to amend that clause 16 to the rest of the clause, Comrade Chairperson, clause 16, Chairperson. Thank you very much.
Thank you very much, Honorable Geller. You meant clause 16.2b.
Yes, Chair, we amend only 16.2b.
Thank you. Clause 17 on procedures. Honorable Sergeant Clark and Harvard.
Freedom from Plus rejects, Chairperson.
The DA rejects, Chairperson.
You. Honorable Harvard, I'm not going to call the names, honorable members. Note your order. Thank you.
Thank you, Chair. And ANC support this clause, no amendment. Thank you.
Thank you. Clause 18, remuneration and reimbursement.
ANC support this clause, no amendments. Thank you, Chair.
Honorable Clark and Van Staden.
The DA rejects. Thank you, Chair.
Freedom from Plus rejects. Thank you, Chair.
Thank you, honorable members. Next part is the chapter 5, which the heading is officer, and 19, which the heading is appointment. Honorable Kaba.
Thanks, Chair. On chapter 5, Chair, on the appointment, the ANC wishes to propose this following amendment, that clause 19.5 be amended as follows. The board may recommend the minister the removal of chief executive officer after a fair hearing if that person, one clause 19.2 be to be amended as follows, that it change to recommendation. Clause 19.2b to be amended as follows. Change recommendations must change to recommendation. Another amendment says that clause 19.3 to be enhanced to read. The minister must, within 30 days from the date of approval by cabinet of the appointment of the chief executive officer, notify Parliament of the final appointment and give the notice of the appointment in the Gazette. Lastly, Chair, on clause point 19, the amendment other we are proposing is that clause 19.5 to be enhanced to read. The board may recommend to the minister the removal of the chief executive officer after a fair hearing, Chair. And then if that person, whatever may be, happened. Thank you. That's our amendment on clause 19, Chair. Thank you.
Honorable Kaba, you're saying clause 95, there's an insertion, it will read, the board may recommend to the minister removal of the chief executive officer after a fair hearing if that person, and the rest of the sentence as contained in the bill will continue there.
Yes, that's what we are proposing, Chair. That's
Yes,
the
thank you.
amendment we are proposing. Thank you.
Yes, Honorable Van Staden and Clark.
Freedom from Plus rejects, Chair.
The DA rejects, Chair.
Thank you. Clause 20, responsibilities. Any members? Honorable Van Staden.
Freedom from Plus rejects, Chairperson.
Thank you. Honorable Clark.
The DA rejects, Chairperson.
Honorable Kaba.
Thank you, Chair. Chair, on responsibilities, clause 20, the ANC proposed the following amendment, clause 20.2.e to amend to read risk management and fraud prevention investigation. And then on clause point 20.3g to amend with deletion of procurement, replace it to health products procurement. Clause 20.3.I to amend to read risk management and fraud prevention investigation. Otherwise, clause 24 and 5, no changes, Chair, up to clause 26, no changes, Chair. Only those amendments I've just mentioned, Chair. Thank you.
Give me a moment, these honorable members. Trying to understand. Honorable Kaba, I'd wish for you to come back to this. Please remind me also to let you come back to this one because I am reading what the clause says. Clause 22E and what you are saying now. I can understand the section 23G and 23I. I can see the changes being proposed, but I would want to give you an opportunity to give a bit just later on at the end. Please remind me. Just give me some clarity on that one, please. Thank you. Honorable members, we are now at, did I give the, yes, Honorable Van Staden and Honorable Clark, did I give you an opportunity?
Yeah,
Yes,
Chair, I don't know if you will want
Yes, that.
All right. I think for safety purposes for myself to remember, I'll always ask Honorable Van Staden and Clark first and whoever comes thereafter, just so that I don't forget to include them. So on clause 21, it is titled Relationship of Chief Executive Officer with Minister, Director General and Office of Health Standard Compliance. I will take the hands first of Honorable Van Staden and Clark, followed by 21, followed by Honorable Northnapa.
Freedom from Plus rejects, Chairperson.
The DA rejects, Chairperson.
Thank you. Honorable Northnapa.
Thank you, Chair. On 21, I would like to amend the clause to read as follows. The Chief Executive Officer of the Fund and the board must meet with the Minister, Director General of Health, and the Chief Executive Officer of the Office of Health Standards Compliance at least 4 times per year in order to exchange information necessary for him or her to carry out his or her responsibilities. That's on 21. Thank you.
Thank you. Clause 22, staff at executive management level. Honorable Sanstaden Clark.
Freedom from Plus rejects, Chair.
The DA rejects, Chair.
Anyone from the ANC? Honorable North-Napel, who else? Clause 22.
Thank you, Chair. On 22, I've got nothing. We will accept it as it is. Thank you.
Thank you. Chapter 6, title the board. Clause 23, title committees of board. Honorable Sanstaden, Clark, and Kaba.
Freedom from Plus rejects, Chairperson.
The DA rejects, Chairperson.
Thank you.
Thank you, Chair. On clause 23, Committee of Boards, the ANC Chair, 23, 1, 2, and 3, and we wish to indicate that we don't have anything here except the proposal we want to make. We want to propose a new sub-clause on clause 23, which, because on 1, 2, 3, and 4, as it has 4 matters, we have nothing to reject on it, only proposing a new sub-clause. Clause 23 to have an addition as follows. 23.5, a member of such committee must A, act in a way that is impartial and without fear or favor or prejudice. B, not expose himself or herself to any situation in which the risk of a conflict between his or her official responsibilities and private interest may arise. Or C, not use his or her position or any information entrusted to him or her for self-enrichment to improperly benefit any other person. That's the new sub-clause of addition we are proposing on 23. Thank you, Chair.
Thank you. Clause 24, technical committees. Honorable Sanstaden, Clark, and who else? Hubbard.
Freedom from Plus rejects, Chairperson.
Thank you.
The DA rejects, Chairperson.
Thank you. Honorable Hubbard.
Thank you, Chair. ANC support clause 24, 1A, B, 24, 2, and also 24, 3, except little bit change for 24, 4. 24, 4 to be amended as follows. A member of such committee must act in a way that is impartial and without fear, favor, or prejudice. B, not expose himself or herself to any situation in which the risk of a conflict between his or her official responsibilities and private interests may arise, or not use his or her position or any information entrusted to him or her for self-enrichment or improperly benefit and others and other person. Thank you, Chair.
Thank you. Honorable Kaba, I'm going to ask again that you lower your hand when you're finished speaking. I would assume that that's a legacy and that is raised there. Honorable members, there was a request for 3 minutes break. It is now 11:58, 1 minute past 12. You have 3 minutes comfort break. Thank you. Honorable members, just to be reminded, we have to finish this work today. Ms. Majalamba. Please ensure that if needed, we will have a few minutes after 11 to be able to complete this work. Thank you, honorable members. 1 minute past 12 back here. Do not switch off your devices and gadgets. Thank you. Honorable members, we are back. We will continue with chapter 7. To start the minister and plus 25, the Benefits Advisory Committee. Any input, honorable members? Honorable Van Staden, Honorable Clark, and Honorable. Any member from the ANC? We'll come to that member. Honorable Van Staden.
The Freedom of Plus rejects, Chairperson.
The DA rejects, Chairperson.
Thank you. Any member from the ANC? Honorable Gela.
Chairperson, on clause
25.
Chairperson, on clause 25, ANC support the whole clause, clause 25, Chairperson, clause 25.1, 25.2. There are no amendment, Chairperson. We support clause 25. On clause 25.3b, we want to amend, Chair, we propose amendment, Chair, to be amended to read as follow. B, Chair, cases to be a member of the committee. And then we delete comrade, Chair, sorry, Chair, when he or she is no longer a member of the institution that nominated him or her, we delete that party chair. And then we remain with when he or she resigns. So we propose that, Chairperson, this clause 25(3)(b) to be cases to be a member of the committee when he or she resigns, Chairperson. Thank you very much. And then we support the remaining clause, Chair, as it is.
Thank you. You are saying it should read as follows. The clause 25(3)(b) ceases to be a member of the committee when he or she resigns, and the ANC supports the rest of the clause as it is contained in the current bill. Honorable Chirwa.
Chairperson, I'm having network problems. I'm sorry about this. I'm having network problems. I don't know if the chairperson is able to share what we had sent to the chairperson on the clause by clause deliberations as well to the department. Because I keep disconnecting and I can't hear what's going on in the meeting.
Yes, it's all been shared with the relevant people. So not only with the department, but also shared with the legal services. There's 3 groups who must work on preparation of the A list. Thank you, Honorable Chairman. Honorable, I will go to clause 26. It's titled the Healthcare Benefits Pricing Committee. Honorable members, I'll start with Honorable Staden, Clark, and then Gela.
Bevrede van Plaas rejects, Chairperson.
The DA rejects, Chairperson.
You.
ANC support the whole clause, Chairperson 26.
Thank you. Clause 27, Stakeholder Advisory Committee. Honorable Van Staden, Clark, and Gela.
Bevrede van Plaas rejects, Chairperson.
The DA rejects, Chairperson.
We support the clause 27, Chairperson.
As contained in the current bill, Honorable Member. Thank you.
Yes, Chair.
Thank you. Clause 28, Disclosure of Interest. Honorable Van Staden, Clark, and Gela.
Freedom van Plaas rejects, Chair.
The DA rejects, Chair.
ANC support the clause, Chairperson.
Thank you. Clause 29, Procedures and Remuneration. Honorable Van Staden, Clark, Gela, and Chirwa.
Freedom van Plaas rejects, Chairperson.
DA rejects, Chairperson.
Chairperson, ANC support clause 29, Chairperson. Thank you very much. No amendment in this clause, Chairperson. We fully support it.
Thank you, Honorable Chirwa.
Thank you, Chairperson. The EFF rejects. Please also note our rejection of the previous clauses. I was just disconnected, like I had said to the Chairperson.
Noted, thank you. Clause 30, Vacation of Office. Honorables Van Staden, Clark, Chirwa, and Gela.
Freedom van Plaas rejects, Chairperson.
The DA rejects, Chair.
The EFF rejects, Chairperson.
Thank you.
Chairperson, the ANC support clause 30, A, B, C. We want to make amendment by adding the following subclause, Chair, in clause D. Act in a way that is not impartial and with fair, favor, or juice in the interest of a specific parties or stakeholders. Each deliberately exposes him or herself to any situation in which the risk of a conflict between his or her official responsibilities and private interests may arise, or F chair, make use of his or her position or any information entrusted to him or her for self-enrichment or to improperly benefit any other person. Those are our amendment, Chairperson, to this clause 30, Chairperson. But ANC will also submit all our proposal later, Chair, to the Secretary of the Portfolio Committee.
Thank you very much, honorable members. Chapter 8. Heading is general provisions applicable to operation of the fund. Clause 31, role of the minister. Honorable Van Staden, Clark, Chirwa, and Kaba.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chair, the ANC supports clause 31. Thank you, Chair.
Thank you, Clause.
The EFF rejects, Chairperson. Sorry.
Yes, thank you. Clause 32, role of department. Van Staden, Clark, Chirwa, Kaba.
The Freedom Front Plus rejects, Chairperson.
The
EFF rejects.
Chairperson.
Chair, the ANC supports clause 32, role of the department.
Thank you. If I miss a clause, please remind me, honorable members. Clause 33, role of medical schemes. Same order. Honorable Van
Chairperson.
Staden. Honorable Van Staden, Clark, Chirwa, and Honorable Hubbard.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chairperson, the EFF wants to add that the bill must make a depiction or of the fact that low cost benefit option is not or should not be regulated by the CMS because it's an insurance, and there already is a state entity for that purpose or department for that purpose that is outside of the jurisdiction of what the bill speaks on. We reject.
Thank you, Honorable Kaba.
Chair, the ANC on clause 33 supports, Chair.
Thank you. Clause 34, National Health Information Systems. Honorables Van Staden, Clark, Chirwa, and Hubbard.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chair, ANC support this clause, no amendments. Thank you.
Thank you, Honorable Chirwa.
Chair, the bill must outline how the old or the existing data will be loaded onto the new system, because it's not in the bill, and how the capacity of that system will be done. It's also not in the bill. The EFF rejects.
Thank you. Just to confirm with Honorable Slengwa that we're still on the same thinking of the support. Honorable Slengwa. Honorable Slengwa. Well, Honorable Slengwa had indicated earlier, I'm going to stay with what had been indicated earlier. Clause 35, purchasing of healthcare services. Honorable Van Staden, Clark, Chirwa, and Kaba. 35.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Thank you. Honorable Chirwa.
The EFF rejects.
Then I see two hands, Honorable Kaba and Honorable Notnagel.
Chair, on clause 35, 1, the ANC proposes that it remains as it is, and also on clause 35, 4.b, the ANC proposed that it remains as it is, and then with other amendments perhaps to come. Thank you, Chair.
Sorry, Chairperson, to disturb you. I'm making a mistake. I thought we were still on 34. I'm unable to hear properly. Can I just add this addition from the EFF 35.4a? Bill must be clear on what the system of reimbursing private emergency services once the cap, because the bill speaks about a cap, that what happens when the cap has lapsed, and who then will be responsible for settling once the cap of the funds has lapsed as stated by the bill. We reject. Thank you, Chairperson.
Thank you, Honorable Notnagel.
Thank you, Chair. If we go to 35.2, the amendment proposed that it must read the fund must and then delete transfer funds and then put in reimbursed payment directly to accredited and contracted central, provincial, regional, specialized and district hospitals based on a global budget or diagnosis related groups. Then point 35.3, the following amendment: funds for primary healthcare services must be, then transferred must be deleted and then amended with reimbursed directly to accredited and contracted primary healthcare providers and establishments, then delete to contracting units for primary healthcare, so that part must be deleted, at the sub-district level as outlined in section 37. Then 35.4a must read as follows: facility-based emergency medical services provided by accredited and contracted public and private healthcare service providers must be reimbursed on a capped case-based fee basis with adjustments made for case severity where necessary. And then the next one, 4A2, mobile emergency medical services provided by accredited and contracted private health care services providers must be reimbursed on a capped case-based fee basis with adjustments made for case severity where necessary. Thank you, Chair.
Thank you. Clause 36, role of District Health Management Office. Honorables van Staden, Clark, Chirwa, and Kaba.
The Freedom Front Plus rejects, Chair.
The DA rejects.
No, clause
EFF rejects.
Clause 36, Chair, ANC supports.
Thank you. Clause 37, contracting unit for primary health care. Honorables van Staden, Clark, Chirwa, and Kaba.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chair, on clause 37, contracting unit for primary health care, ANC proposes an amendment on clause 37.1 to be amended as follows. A contracting unit for primary health care established as component of the fund in terms of the national health insurance. Here, Chair, we are deleting of section 31B and we are deleting of section, we are also deleting of section 31C, Chair. We are saying 37.1 to be amended as well. A contracting unit for primary health care established as component of the fund in terms of the National Health Insurance Act. Through Chair, we are proposing the following amendment. Remove from the amendment of the National Health Act in the schedule and include relevant details in clause 37 of the NHI Bill to be read as follows. Clause 37.1A to amend as follows. Clause 37.1A for the funding of accredited and contracted public and private healthcare providers, an establishment for such as prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care in demarcated geographical area.
Honorable Kaba, can you just reread that, please?
Yes, please. I will do so, Chair.
From
We
clause
are,
37(1)(a), what you want to be amended?
we are saying, Chair, to be amended as follows. A contracting unit for primary healthcare established as a component of the fund in terms of the National Health Insurance Act. That's the amendment, Chair. Further proceeding, Chair, that clause 37, I've already read clause 37(1)(a). I'm now proceeding.
That's the one I want you to read again, please.
Okay, thank you. Clause 37(1) of A to be amended as follows. To be amended as follows, Chair. That the plan for the funding of accredited and contracted public and private healthcare providers and establishment for such as prevention and promotion, curative, rehabilitative, ambulatory, home-based care, and community care in demarcated geographical area. That's what I'm proposing, Chair. And then on clause 37.1B, to be amended as follows. Is the organizational unit through which the fund facilitates the development of contracts to be entered into between the fund and public and private healthcare providers and establishment for the provision of the primary healthcare services within a specified geographical area. C, the units established in terms of subsection 1 must be directly contracted by the fund established to ensure the contracting provision of primary healthcare services, including prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care. D, the fund must transfer funds directly to PHC providers that have been contracted through the contracting units for the primary healthcare guided by the district health resources allocation formula or capitation formula prescribed by the fund. Lastly, Chair, the amendment to clause 2.
Honorable.
Yes, Chair.
Honorable Kaba.
Yes, can I continue?
Before you go to the next one, I need a bit of clarity from you, please. Clause 37(1)(b). Can you say what is being deleted? And then number 2. If
okay.
I see on the bill, I don't see a C and D. Are you saying these are new additions to the bill, new subclauses?
Chair,
C and D. Please indicate so.
Yes, on the clause 7.1B, Chair, to amend it as follows. B, Chair, to be of clarity, that is the, we delete prefect, is the organizational unit through which the fund facilitates the development of contracts to be entered into between the fund and public and private healthcare providers and establishment. For the provision of, and then we delete, of which for the provision of primary healthcare services within a specified geographical area. That is the B. Then we have C and D, which I wish to indicate that we must give clarity to, Chair, that the units that are established in terms of subsection 1 must be directly contracted by the fund established to ensure the contracting provision of primary healthcare services, including prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care. Then on D, Chair, the fund must transfer funds directly to PHC providers that have been contracted through to the contracting units for primary healthcare guided by district health resources allocation formula or capitation formula prescribed by the fund. Safe to mention, Chair, like as Honorable Gela indicated, we will submit also our amendment to you and the Secretary to the end, but further going to request amendment to clause 2, Chair, to read as follows. 37.2, we are adding. Each unit will be responsible for the population in its designated sub-district as determined by regulation and must ensure that the required funding allocations for the capitation are determined and human resources are placed to provide primary healthcare services. So those are the amendments here which we are proposing on clause 37. Are we clear, Chair? Hello?
Yes, thank you, Honorable Kaba. I just give me a second. I need to look at something, clause 37. And where is my vote? Give me a second, please, honorable members. Thank you. I've just cleared myself. So the next clause is clause 38, which has as its heading Office of Health Products Procurement. Honorable Sonsaden, Clark, Chirwa, and Gela.
Freedom from Plus reject, Chair.
The DA rejects, Chair.
Honorable Chirwa and Honorable Temakwai has asked to be let in. I don't know if she's let in yet to the platform. Please note, Ms. Majalamba. Honorable Gela.
Thank you, Chair. On clause 38, Office of the Health Product Procurement Chairperson, we want to make amendment as African National Congress. All clauses under clause 38 and anywhere in the bill of the Office of the Product Procurement to be changed to read as a health product procurement unit, Chairperson. 38, clause 38.1, Chair, change any reference to Office of the Product Procurement, the OHPP, to a health product procurement unit. Clause 38.2, Chair, change any reference to Office of the Health Product Procurement, the OHPP, to Health Product Procurement Unit. Clause 38.3, change any reference to Office of the Health Product Procurement, the OHPP, to Health Product Procurement Unit. From A, Chair, B, C, D, E, F, G, H, I, Chairperson, as ANC, we support that, comrade, no amendment. But coming to 4, Chair, clause 38.4, change any reference to Office of the Product Procurement, the OHPP, to Health Product Procurement Unit. Then number 5, Chair, 5, 6, 7, there are no amendment, Chairperson. Thank you very much, Chair. We support, Chair.
Thank you. Thank you. Honorable Kaba, I would assume again you hadn't lowered your hand.
Oh, thank you, Chair. I was ready for the next clause. Thank you.
No, you must lower in between, Honorable Kaba, because I will take the hands which are raised. Thank you. Clause 39, accreditation of health of service providers. Honorable Van Staden, Clark, Kaba.
Freedom from Plus rejects, Chair.
DA rejects.
Thank you, Chair. On clause 39, Chair, clause 39.1, Chair, the ANC supports. On clause 39.2, we would like to propose the following amendment. That clause 39.2A be read or to be enhanced and rephrased as follows. In order to be accredited by the fund, a healthcare service provider or healthcare establishment, as the case may be, must A, point I, be in possession of and produce proof of registration by a recognized statutory health professional council, as the case may be. A, point Roman figure 2, be in possession of and produce proof of certification as graded by the Office of Health Standards. Further, Chair, we amend that, we propose that the amendment on clause 39.2B to be enhanced as follows. B, meet the needs of users and ensure service provider compliance with prescribed specific performance criteria, accompanied by budget impact analysis, including any other thing. Thank you. And then, Chair, and then on I, we propose, we don't have anything we propose it remains at this I, Roman figure I, Roman figure 2, 3, 4, 5, and 6, and 7. And then on 3, Chair, also we propose that it remains as it is. On 4, we propose that it remains as it is. And only on 5, Chair, 39.5 that we are saying, the amendment be proposed as follows. 39.5 to be amended as follows. In order to be accredited and reimbursed by the fund, a healthcare provider or healthcare establishment must submit information to the fund. Then we delete for recording on the healthcare patient registration system. We replace it with through an information platform as prescribed and accredited by the fund. Also, Chair, that on clause 39.6 to be amended as follows. That 6, the performance of an accredited healthcare service provider or healthcare establishment must be monitored and evaluated in accordance with this act, and appropriate sanctions must be applied where there is deviation from contractual obligation as per law and prescribed in regulation. Then, Chair, also that clause 39.7 be revised as follows. That 7A, the fund must renew the accreditation of service providers every 5 years of the basis of compliance with accreditation criteria as reflected in subsection 2. Then 7.B, Chair, that public health establishment in undeserved and rural communities must be provided graded certification as provided for by the OHSC with conditional accreditation. That is to be prescribed through regulation in clause 55 of 1 of H. Then on clause 39.8, we are saying no changes here as ANC. However, 8B, we are proposing that it be revised as follows, that we are proposing on Roman figure B1 is no longer in possession of or is unable to produce proof of certification by the Office of Health Standard Compliance of proof of registration by the relevant statutory health professions council, as the case may be. Roman B figure 2, Roman B, and then B Roman figure 2, because I'm from A1, Roman B figure 2, that an exception be made to public health establishment in rural and undeserved areas that have been graded conditional accreditation. Then on C, Chair, no changes. D, no changes. E, no changes. F, G, H, I, and J, and K, Chair. And then my submission, Chair, will then speak also to 39.9 clause, and in particular E, that this must be enhanced with the following subclauses. The duration of the notice must be prescribed in regulation. Then on clause 39.10, no changes as the NC, Chair, and clause 11, we are also saying no changes, Chair. So that will be my submission with those enhancement and amendment, Chair. I've also yet used, Chair, saying other members are proposed to be released and so on. I think we are still proceeding with the meeting, but we welcome the inputs and clarities that were requested by Honorable Shirwa of her participation on this bill, Chair. It means that is a positive mood for our meeting. Thank you, Chair.
Thank you, Honorable Kaba. I just need to correct something that you said. So it's not Roman figure I, it's Roman figure 1. And I'm going back to it just to make sure that you certain that was clause 32, 39 to be Roman figure 1. And then another one is
that is Roman figure, not I. Yeah.
It needs to be captured correctly. And the next one is on another one. It's where it was a similar, close to a similar. Give me a moment. Yes, it was 39.8B2. Just to capture that it's that where you read an exception will be made to public establishments in rural and underserved areas that have been granted graded conditional accreditation. That takes us, honorable members, to clause 40. I write now. Yes, information platform fund. I'm going to give Honorables van Staden, Clark, and Gela. Honorable Kaba, if you please lower your hand if it's not your turn. Staden, Clark, and Gela.
The Freedom Front Plus rejects, Chairperson.
The DA rejects this clause.
ANC support, yes, Chair. ANC support clause 40 as it is, Chair.
Thank you. Clause 41, payment of healthcare service providers. Honorable van Staden, Clark, Gela.
Chair, on a point of before, I have a request to make, if you allow.
Yes, you're welcome.
Yes, Chair. Yes, we just want to clarify our point on clause point 87, Chair. If you will allow.
Come back to that, Honorable Kaba. Let me stay in what I'm doing, please. You can do that at the end.
Thank you, Chair.
It's not going to be taken back in this process. Now I'm not even sure what I said now. Was I now on clause? Just remind me now.
41, Chair.
Thank
41.
you. Clause 41. Honourable van Staden, Clark and Geller.
Freedom Front Plus rejects this clause, Chairperson.
The DA rejects this clause.
ANC support clause 41, Chairperson 41.1, 41.2. Then we want to make submission, Chair, amendment on 41.3A to be amended as follow. An accredited healthcare service provider or a health establishment providing a primary health care services, we must delete must be. If you can delete must be, Chair, and then contracted through a contracting unit for a primary health care will be reimbursed by the fund using a capitation strategy. And then on B, Chair, there are no amendment, we support it. And then C, we support it, no amended. 4, Chair, we support as ANC as it is. B, we support. C, we support. 5, Chairperson, we support as it is, Chair. Thank you very much.
Thank you very much. Honourable members, we are close to the 2 complaints. Honourable van Staden, Clark, and Howard.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chairperson, ANC support clause 42, 1, 2, 3, 4. No amendments. Thank you.
Thank you. Clause 43, lodging of appeals. Honourable van Staden, Clark, and Howard. Right?
Freedom Front Plus reject, Chair.
The DA rejects, Chair.
ANC support clause 43. No amendments. Thank you, Chair.
Thank you. Appeal Tribunal. Honourable van Staden, Clark, and 44, and Howard.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
ANC.
Chair, clause 44, 1, ANC want to make amendment, Chairperson, to be amended to read: an appeal tribunal is hereby established, consisting of 5 persons appointed by the minister after a consultation with the cabinet. Clause 44, 1A, Chair, to be amended also, Chair. 1 member appointed on account of his or her knowledge of the law, who must also be a chairperson of we delete the board, Chair, and then we remain with appeal tribunal. Thank you. And then clause 2, Chair, no amendment, Chairperson. We support the clause it is. And then clause 3, A, B, C, no amendment, Chair. Thank you very much, Chairperson.
Thank you. So that's appeal tribunal.
Yes, Chairperson.
Thank you. Clause 46, title secretariat. Honourable van Staden, Clark, Geller.
The Freedom Front Plus rejects, Chairperson.
The DA rejects.
The ANC support the clause, Chairperson, but we propose clause 66 to be amended, Chairperson, as follows. Sorry, Chair. The Chief Executive Officer of, we delete the board, and then we remain with the, we put a fund, must designate a staff member of a fund to act as a secretary of the appeal tribunal, and the fund must keep the minutes in all records of the decision of the appeal tribunal for a period of at least 3 months, 3 years after the decision has been recorded, Chair.
Thank you. So, Honorable Gela, you're saying in the two positions where the word board has to be deleted and it has to be replaced by the word fund. And the second word board, where board is deleted, it's replaced by the words appeal tribunal.
Yes, Chair.
Thank you. Clause 47, title, procedure and remuneration. Honorables van Staden, Clark and Gela.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
ANC support Chairperson clause 47(1), no amendment, and also clause 2, no amendment, Chairperson. We support.
You're saying clause for, sorry, Honorable Gela, you're saying clause
47(1) and 2, we support as ANC, no amendment, Chairperson. Coming to clause 47(3), we want to amend, Chairperson, to be amended as follows. The appeal tribunal must determine the outcomes of the appeal within, and then we delete 180 to be 90 days after the lodgement of the appeal, and inform the appellant of the decision in writing, and the secretariat appointed in the section 46 must keep records of all proceeding and outcomes. The decision that is being appealed against is suspended pending the outcomes of the hearing, Chairperson. And then 4, there are no amendment. We support it, Chairperson. Thank you.
Thank you. Chapter 10, financial matters, sources of funding, clause 48. Clause 48, titled sources of funding, Honorables van Staden, Clark and Kaba.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chair, source of funding, the ANC wishes to raise that the revenue source of fund, we have nothing on A, but on B, we are proposing deletion of clause B, that any fines imposed in terms of this act, other than by a court of law, that it be deleted. Otherwise, all is well. Thank you, Chair.
Thank you. Clause 49, titled chief source of income, Honorables van Staden, Clark and Kaba.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chair, on 49(1), Chair, the ANC proposed that it remains as it is. On 49(2), amendment proposed as in addition to clause 49.2A, Roman figure 1, as follows. We must include shifting funds from national government, department and agencies, and from the provincial equitable share and conditional grants into the fund. And then on clause 49 2B, we have nothing, Chair. And on 3, we say it must remain as it is. And that is our submission on clause 49, Chair.
Thank you. Clause 50, auditing, Honorables Van Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chair, the ANC proposes that it remains as it is, Chair. Thank you.
Thank you. Clause 51, annual reports, Honorables Van Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chair.
The DA rejects.
Chair, the ANC proposes that it remains as it is, Chair. Thank you.
Thank you. We're on chapter 11, miscellaneous. Clause 52, assignment of duties and delegation of powers. Honorables Van Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Chair, the ANC proposes that it remains as it is, Chair. Thank you.
Thank you. Clause 53, protection of confidential information. Honorables Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chair, the ANC proposes that it remains as it is, Chair.
On clause
Thank you.
54, offences and penalties. Honorables Van Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chair, the ANC proposes that clause 54, 1, A, B, C, and D remain as it is. However, we wish to make an amendment on E that proposes as follows. We propose to insert the word confidential into clause 54.1 E and to read as follows: sells or otherwise discloses confidential information owed by the fund to a third party without the prior knowledge and written consent of the fund, is guilty of an offense liable on conviction in a court of law to a fine not exceeding 100,000 or imprisonment for a period not exceeding 5 years, or both a fine and such imprisonment. Then on 2 and 3, Chair, we propose that it remains as is. That is the only amendment we are proposing on 54. Thank you, Chair.
Thank you. Clause 55, regulations. Staden, Clark, and Kaba.
Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
Thank you, Chair. Clause 55, the ANC proposes that it remains as it is: 1A, B, C, D, and E, F, G, and H, Chair. K, A, L, I, M, Q, R, S, T. We are only proposing that on you, Chair, that the amendment proposed on clause 55L, U must be deleted. And Chair, then we propose, we continue other clause remain as they are up to 2, 3, Chair. And on the last one, number 4, on the regulation, we are proposing the deletion proposed as follows: that proposal for clause 55.4 to be deleted at all. So that's what we are proposing, Chair. That is our proposal on clause 55.
Thank you. So, Honorable Kaba, I would assume that when clause 55 is it now 1U removal, let me just go back a little bit. 55. Wow, 1U, when it's deleted, it stands to reason that the other clauses just shift up, subclause, subclauses just shift up, becomes UP, etc. Moves on again, just for the legal sake of procedure that I'm mentioning this. Honorable members, clause 56 directives. Honorables van Staden, Clark, and Kaba.
Chairperson, the Freedom Front Plus rejects this clause.
Chairperson, the DA rejects this clause.
Chairperson, on the directives on clause 56, the ANC proposed that it remains as it is.
Thank you. Clause 57, transitional arrangements. Honorables van Staden, Clark, and Kaba.
Chairperson, the Freedom Front Plus rejects.
Chairperson, the DA rejects.
Chairperson, on clause 57, point 1A and B, the ANC proposed that it remains as it is. However, on 57.2, Chair, we would like to propose the following. Clause 57.2A must be amended to read as follows. Phase 2 was conducted between 27 to 2023 and focused on, because we are deleting here on clause 57.2 phase 1, correcting it with phase 2, and then also deleting for a period of 5 years from between, and we are also saying, Chair, as I repeat myself, clause 57.2A must amend to read as follows. Phase 2 was conducted between 2017 to 2023 and focused on. That's what we are proposing to give clarity. And then on B, on 57.2B, an amendment proposed, Chair, here is that phase 2 must be for a period of 4 years from 2023 to 2027 and be aligned with progressive realization of the UHC goals and must include. It is further proposed that a new subclause for the establishment of administrative capacity in preparation for a fund is included to and read as follows. Clause 57.2.b to be amended with addition of the following subclause, that be Roman figure 4. Preparation for the establishment of the fund as a Scheduled 3A entity contemplated in section 9, the minister must, in consultation with the Minister of Public Service and Public Administration, and establish an appropriate administrative capacity to develop and prepare the functions of the fund. And on 3, Chair, we are proposing it remains as it is. 3A, 3B, it remains as it is. 3C and D remains as it is. And on 4, Chair, 4A remains as it is. B remains as it is. C remains as it is. D, 4D, 4E remains as it is. 4F remains as it is. 4G, H, Chair, and on 5, Chair, also remains as it is. That is our proposal on clause 57. Thank you, Chair.
Thank you. Clause 58, repeal or amendment of clause. Honorables van Staden, Clark, and Bella.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
ANC support clause 58, Chairperson, as it is.
Thank you. Clause 59, short title and commencement. Honorables van Staden, Clark, and Bella.
The Freedom Front Plus rejects, Chairperson.
The DA rejects, Chairperson.
ANC support clause 59, Chairperson, as it is, Chairperson, no amendment.
Honorable members, let me congratulate you on good work that has been done. We've now finished with the clauses up to clause 59. We're going to deal with part B, which is section 58, the repeal and amendment of legislation affected by this act. I hope we are all on the same page here. I will take the hands of Honorable Sergeant Clark and Honorable and these of course are also for the schedules. And I will take the hands Medicines and Related Substances Act 101 of 1965 as amended. Honorables Sergeant Clark, Kaba.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chair, the ANC on medicine and related substances, Chair 101 of 1965 as amended, especially on 22.G, we wish to raise that, Chair, maybe it read as follows: the minister shall, in consultation with the Health Products Procurement Unit established in Section 38 of National Healthcare Insurance Act 2018, appoint for expenses to any person that the state, the National Health Insurance Fund established by Section 9 of the National Health Insurance Act 2019, or any other person. That is the input we would like to make on that matter. Thank you.
Thank you. Next is the Occupational Diseases and Mines and Works Act 78 of 1973 as amended. I will take the hands of Honorable Sergeant Clark and Gela.
The Freedom Front Plus rejects, Chair.
The DA rejects, Chair.
Chairperson, the ANC support Chairperson, the clause 36, the cost medical examination. The cost of any medical examination under this act and the cost occurred to keep a person under observation in accordance with any provision of this act shall be purchased and paid for by the National Health Insurance Fund established by Section 9 of the National Insurance Act 2019. In the case of a person who works or a mine or works or whom the owner of the mine or works intends to employ, to be borne by the owner of the mine or works, and in the case of any other persons be paid by the Director General from monies appropriated by the Parliament for that purpose, Chairperson. And also, Chair, under occupational...
Honorable Gela, sorry for my intervention.
Yes, Chair.
I am just trying to remember and recalling whether these amendments have not been forwarded, these suggestions have not been forwarded already. And these are going to, we cannot go through every one at this point in time. I think what should be said here is that if there had been amendments proposed by the ANC and by the department earlier, that we accept those, except for the ones where we think that there ought to be further amendments to any of these acts. And I think I am correct. The intention is not to read each one of these again. Honorable Kaba, you raised your hand.
Chair, yes, Chair.
Thanks, Chair. Chair, yes, I think Honorable Gela was trying to be explicit to you, but however, Chair, we wish to raise that as ANC, we support these amendments, except, Chair, that we would like to read on the National Health Act 2004, number 61 of 2003, that is on 31, if you allow me, Chair, because with other amendments we here as ANC we support. I don't know if can I read it for you, Chair, because
yes,
that's
I just want to make sure that Honorable Gela is with us on the same page. We're not going to go through all of these acts, honorable members. We have done that, but I hear that there's a proposal for an amendment of the National Health Act. Honorable Kaba wishes to read that. Please go ahead.
Thank you, Chair. On National Health Act, Chair, that is on 31. I just preparing myself while here, Chair. Yes, I'm ready now, Chair. On National Health Act, Chair 31, 31.2A, a district health council consists of, that is 31.2A, but there is Roman figure 4, not more than 5 other persons appointed by the relevant member of an executive council after consultation with the municipal council of the metropolitan or district municipality or district health management office, as the case may be. 31.3, Chair, district health must A, promote cooperative governance, 2, ensure coordination and planning, budgeting, provision and monitoring of all healthcare services that after residents of healthcare district for which the council was established. B, promote community participation in planning, provision, evaluation of healthcare services. C, advise the relevant members of the executive council through the provincial health council and municipal council of the relevant metropolitan or district municipality or on any other matter health services in the health district for which the council was established. 31.5, Chair, provincial legislation must at least provide for A, the function of the district health council, B, the approval after consultation with relevant district health council by relevant member of the executive council and municipal council of the metropolitan or district municipality, as the case may be, of detailed, we delete budget but of the detailed performance targets for health services in health district to which the both provincial and municipal spheres of government must contribute. And C, Chair, Roman figure 1, deadlock breaking mechanism for cases where agreement between relevant member of the district health council.
Honorable Kaba.
Yes, Chair.
Can I stop you, please? It's not what you indicated you wanted to bring an amendment to. This has already been read before. If I understand you, you wanted to bring an amendment on 31B. Can you go to that, please, and not go through the entire 31A? Thank you.
Oh, okay, Chair, I'm with you, Chair. Thank you for the guidance, Chair. I'm heading to that one. Okay. That 1B, Chair, the proposed amendment is as follows. That it is proposed that the amendment that 1B, the National Health Act, to be moved to clause 37 of National Health Insurance Bill and deleted from the National Health Act amendments. That clause 31B1 of amendments to the National Health Act must be amended and moved to clause 37 of the bill and must be read as follows. The units established in terms of subsection 1 must be directly contracted by the fund established by section 9 of the 37 of the National Health Insurance Act 2019 to ensure the contracting provision of primary healthcare services, including prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care. That 1B3, Chair, the fund must transfer funds directly to PHC providers that have been contracted through the contracting units for primary healthcare guided by the district healthcare resources allocation formula or capitation formula prescribed by the fund established by Section 9 of the National Health Insurance Act 2019. That, Chair, also that 1B4 must be amended as follows. Each unit will be responsible for the population in its designated sub-district as determined by regulation and must ensure that the required funding allocations for the capitation are determined and human resources are in place to provide primary healthcare services. That 1B5 Chair must be moved to National Healthcare Amendment Act to clause 37 of the National Health Insurance Bill, to clause or statement inaccurate and should not be amended further. That 1B Chair clause must be amended to further read as follows: to the extent that the contracting unit for the primary healthcare are not adequately capacitated, the National Office of the Fund District Health Management Office must perform these functions on its behalf until such time as the units have been sufficiently capacitated to fill their purposes as provided for in this section. That 1B6 Chair, to the extent that the contracting units to primary healthcare are not adequately capacitated, the District Health Management Office must perform these functions on its behalf until such time as the units may have been sufficiently capacitated to fulfill their purposes as provided to in this section. Thank you, Chair.
Thank you, honorable members. We've just had a marathon. Just for everybody listening, it's good to participate in sport. It puts you in a good place to be able to participate in such lengthy programs. So I'm advocating good health, exercise routine, and proper eating habits at the same time. Thank you. So, honorable members, there were 2 points which I wasn't certain of. And one is clause 37(1)(c), which I think needed to be read again. I can't remember who actually read the clause 37(1)(c), and there was also clause 2(a). I'm going to try to go back where we were, 37(1)(c). I need that to be much clearer.
Yes, I can read, Chair.
37(1)(c).
Yes.
Honorable Kaba, let me finish. I'll tell you when I'm ready, please. 37(1)(c), yes. Honorable Kaba, please read.
Thank you, Chair. The ANC on 37(1)(c), Chair, wish to raise that the unit established in terms of subsection 1 must ensure that the provision of primary healthcare services, including prevention, promotion, curative, rehabilitative, ambulatory, home-based care, and community care, are contracted for by the fund. That's our input on 37.1C. Thank you, Chair.
Thank you. And then I wanted clarity on 22E. I'm just scrolling to 22E. So 2, yeah, so I could have, I don't see 22E, I wrote 2, let me see, 2. Yes, there's no 22E. Honorable members, I actually mentioned this to the member who was speaking. I hope that member would have noted what I was asking. Would have been 37(2)(e), 22E. Honorable Kaba, I thought that was you who had spoken at that time. No. Oh, well. I'm
Okay,
certain
Chair, I can, if you want me to come in, Chair, I can.
Yes, do you remember me saying that I needed you to give a little, for my purpose, a bit more clarity, but if it had been captured by those who had to do capturing, and if it's captured by the input which you will be sending in the manner that you had provided, it is fine. I don't need to be clarified more than what will be sent on the written submission on what you had stated. Because I see there isn't a 22E.
Yeah,
Do you
Chair,
remember what I
yeah.
was speaking to, Honorable Kaba?
No, Chair, I think on our submission, it will be submitted, Chair, but on 37.2, Chief, we were saying we add each unit will be responsible for the population in its designated sub-district as determined by regulation and must ensure that the required funding allocations for the capitation are determined and human resources are in place to provide primary healthcare services. That's what we're saying, Chair, on amendment to clause 2 on 37.2 that we added, but on our submission it will be clearly written. Chair, thank you.
Thank you very much. So, honorable members, we're a little bit over time that we've allocated for this meeting today. Let me express my gratitude once again to all of you for your participation, for the good manners we had all shown here today, and the example that we had shown to the public of South Africa in us being able to do this work to the point where we are now. We have 2 outstanding meetings on Friday, and I had already indicated that this would be drawn up by the Parliamentary Legal Services, and that they have indicated that they accept my instruction, and they will be assisted by the department persons, legal persons from the department, and the state law advisors. Need to make sure that these are properly recorded, drafted, and presented accurately for us to be able to deliberate on the A list on Friday. So I have only 1 or 2 things. I see the hand of Honorable Clark, whom I'm going to give an opportunity to. Honorable Clark.
Thank you, Chairperson. Just a short indication that the DA will be sending an updated minority report in terms of Rule 288.3F of the rules, in terms of the bill today again. Thank you.
Thank you. Not later than today, Honorable Clark. I am proceeding with the work on the 12th of May. We all have had opportunities to do that. You've been remarkable for all of the political parties. And so, and that deadline had expired, and I hope there's nothing new that will be added, because I had even indicated many times and even had given an extension to that deadline, I think at least once or twice. So we are at the point where the legal service of Parliament will go up this A list and come and present it to us themselves on Friday, assisted by the state law advisors and the legal services persons of the department. So, honorable members, just to remind you, I think our meeting, Ms. Majalamba, starts at 9:30 on Friday morning, if I am correct. And we will then have a good discussion on the list that is then presented to us. I don't think there is any, oh yes, sorry, before we go. We also had some minutes we wanted to consider and adopt, Ms. Majalamba. I'm sure we have another few minutes to be able to do that. Ms. Majalamba. So I'm going to ask the other persons who are logged into our meeting, that I'm going to say that they can leave the platform should they so wish. I'm sure we have all other work to perform. And then we're going to do, just as a committee, the minutes. And then we will adjourn shortly after that. So, honorable members, there are the minutes of the 3rd of May of the Portfolio Committee on Health. It was for consideration and adoption of the committee's budget report and consideration and adoption of minutes. Make sure that you've been noted to have been present, and if you have tendered an apology, that is also noted. Please scroll, next page. And it was to adopt the committee's BRR report. And anything omitted, anything you want to add? Nothing, next page. Those were the discussions, honorable members. Anything you want to raise? Next page. Can I ask for somebody to move for the adoption of these minutes?
Chair, I move that the minutes.
I second
Who
the
is
chair.
speaking now? That's that Afrikaans speaker there. Please mute your microphone. Any seconder for the adoption of the minutes?
I second the chair.
Thank you. Next set of minutes, Ms. Majalamba.
We are done, Chair. Thank you. Those are the only minutes.
Thank you very much. Honorable member, thank you once again. Just certain, Ms. Majalamba, just for me to be absolutely certain, we start at 9:30 on Friday morning.
Yes, Chair.
And then, honorable members, I've been requested to do a keynote address tonight at the Born to Soon global launch. There's a full name of it. I will provide that full name to you again. So on behalf of the committee, I will be doing that as requested by the Speaker of the House this evening. Thank you very much. Have a great day. All of you must attend the plenaries now, and we'll see you on Friday. This meeting is adjourned.
Thank you, Chair.
Thank you. Thank you, Chair.
Thank you, Chair.